Any mention?
My lord, I beg to crave my lord's indulgence. There's a very urgent matter, my lord, where I'm seeking a very limited intervention of this court. What happened was that there was a suit filed against me, eviction suit, and subsequently I was given a legal aid counsel, and I was never informed that the legal aid counsel has abandoned my case, and this suit went ex parte against me. So there was no proper representation on my in my favor, my
Legal
lord.
aid counsel?
Legal aid counsel, my lord.
From where? From here?
District council, my lord. It's a matter. So now, no proper representation was given to me, my lord. Now, what happened was that there's a ex parte judgment and order, a decree, and the decree is going to be executed today, my lord. So now I'm going to be dispossessed.
Go by CRP.
My lord, very limited, because my only point is, my lord, till such time that I take a proper recourse, my lord, to a district, because of course there's a alternative remedy is there, but it's not very imminent, my lord.
Why?
Immediate, my lord. Because now I'll file, my lord, and I just got a brief on the Saturday, my lord, and so just very limited.
Expect a writ to intervene. When was the decree passed?
The decree was passed on the 5th of March 2026, my lord, which I've come to know very subsequently, my lord, when there's an order.
When was the suit abandoned?
The suit was abandoned, my lord, somewhere in the year 2024, my lord. And till then, I was never made to
There
aware.
was no contact between you and legal counsel?
No, my lord. No, my lord. And subsequently also, my lord, the legal aid counsel, my lord, when I came to know that there was a suit went ex parte against me, legal aid counsel has assured me that he or she was going to file a restoration application, which was not filed and was never informed me.
She didn't file any other 9 Rule 13 application?
My lord, what happened now is, my lord, subsequently also there was an application filed that for setting aside that application was clubbed together with Section 5 of the Limitations Act. That happened Thursday by some other legal aid, my lord. So, my lord, then the court says that no, how can you file and club?
What 9 Rule 13 application?
Yes, my lord. Club together with a Section 5 Limitations Act, my lord. So the court says, and I cannot, because these are defective applications. Now, my lord, I have been exposed to a danger, my lord. So,
by writ. Well, you file it, we'll see.
My lord, at the end of the board, my lord, I'm just seeking for 5-10 days of intervention, my lord. That's all, my lord. Much obliged.
May I please, your lordship. Lordship, I beg to mention item number 82, lordship.
Yes.
Lordship, the learned counsel is from Guwahati and he is indisposed, lordship. So
it doesn't matter where he's from, might be from Mars
yes,
also.
lordship.
May the local
pray for
counsel,
2
you
weeks.
argue it.
May I pray for 2 weeks' time, lordship?
Why? You don't have a brief with you?
No, lordship. The complete briefs are not with me.
Next time, no adjournment if you on the basis that my counsel from Guwahati. You be sick or something different. Yes.
Deeply obliged, lordship.
Yes. Yes.
I beg to mention item number 36, lordship. Mr. Chanda was supposed to argue this matter, lordship, but on medical grounds is not available today, lordship.
Yes.
Hmm?
Yes, 2 weeks.
Mr. Chanda.
Yes.
Yes, sir. Lordship.
Yes.
Deeply obliged.
May I please, your lordship, I beg to mention item number 81. I'm praying for 2 weeks' time, your lordship.
Yes.
Your lordship.
May I please, your lordship. Your lordship, I beg to mention item number 34, your lordship.
Lordship.
You have to chin.
They're asking for adjournment, Lordship.
Why?
Your lordship, we had sought for clarifications. We're still waiting for those clarifications, your lordship.
That's correct.
Yes, your lordship.
Not away.
They actually, this matter was heard at some length, Your Lordship, and they are supposed to seek some instruction.
With regard to?
This is regarding suspension of the petitioner from service, Your Lordship.
Your lordship, there's a criminal case pending against him, so.
How much time?
2 weeks, your lordship.
You 2 weeks. Yes.
Much obliged, lordship.
May I please, your lordship? I beg to mention item number 33. I'm praying for 1 week time, your lordship.
The retreat was heard?
No need, lordship, not yet.
Why?
Your lordship, the contending counsel is in the different court, your lordship.
That's an excuse. Which chamber are you from?
Senior Advocate SP Mahanta.
That's not an excuse to make. We can have it end of the board. If you're ready.
No, Your Lordship, he has a lot of matters today.
There's no excuse. Yes. You no objection?
No objection, Your Lordship.
Yes. Everybody lots of matters. Yes.
Much obliged, Your Lordship.
Much obliged.
Please, Your Lordship. Your Lordship, I beg to make a mention of item number 83, Your Lordship. I'm praying for 2 weeks' time, Your Lordship.
What's the matter about?
It's a tender matter, Your Lordship.
Why? No urgency?
No urgency, Your Lordship. No objection.
Yes.
I will grant.
Please, Your Lordship. Your Lordship, I beg to mention item number 79, Your Lordship. Lordship, I am praying for 2 weeks' time, Your Lordship.
No, I have no objections.
Yes.
Alright.
Item number 1.
So this is a contempt against the order of 27/11/2025. My Lord will find the operative part as page 9 and 10. Para 5.
Yes.
That this court notes as seen from the affidavit of the respondent number 6 that though the names of the children have been incorporated in the pension payment order, the name of the petitioner was not included in view of the fact that her name was not shown at the time of submission of the said paper. On the completion of the next of kin certificate sponsored by the Land Council for the petitioner, which is taken on record, it thus appears that the impediment no longer exists as such. The family pension can be released in accordance with law. Next page, Lordship. 2 months time.
Release.
No, Lordship.
Heard Mr. S.A. Sheikh issue notice returnable in 3 weeks. In 2 weeks, steps to be taken by, I said, AD within 3 days. Which is the department?
It's a community and rural development.
Yes.
No?
Item number 2.
Maso.
What is this?
My Lord, this petition has been filed against the order dated 13 February 2026, my Lord. The petitioner was deprived from the benefit of old pension scheme, my Lord. He was recruited as a rifleman GD against the notification advertisement published on 12th November 2003.
Where's the impugned order?
Impugned order as page number 37, my Lord, Annexure 10.
Not eligible for conversion.
My Lord,
on what ground was it rejected?
Did nothing, my Lord, nothing as shown. That is typed copy as page number 38, my Lord. Paragraph number 2. It is intimated that as per office memorandum number so and so, you are not eligible for the conversion of OPS, my Lord. Simple.
What did you file in Guwahati?
Guwahati, my Lord, the earlier the writ petition was filed for the prayer of the reinstatement into service, my Lord. But which was withdrawn, my Lord, because of the medical ground, my Lord. The petitioner is not fit to rejoin his duty, my Lord. Otherwise, similar benefit has been granted to the same persons, my Lord, who was recruited.
Mr. B. Kumar, the Council issue notice. Dr. Musika with MS C. Jala is present. And no further notice required this respondents. This over 3 weeks for after instruction.
3. 3.
Praying this matter will be taken up tomorrow, my Lord.
Why? What's the matter
Mr.
about?
Paul has some personal difficulty today, my Lord.
Yes.
We have come against the order of suspension as well as the show cause notice, my Lord.
Why you come against show cause notice?
My Lord, may kindly see the allegation of statement of allegation, my Lord.
Which
at
page
page
is it?
72, my Lord. There's no definite charges were framed against me. There's no independent inquiry also, my lord. Merely, my lord, a criminal case has been is pending and charge sheet has been filed.
That's all.
That's all, my lord.
Where's the show cause notice? This one.
Show cause notice at page 70, my lord.
Oh, charge sheeted in another case, 420. Then you submit a show cause.
My lord, there's no definite charges were framed against
No,
me, my
because
lord.
you're involved in a case. This is received from investigating officer that you're involved with 120, 420, so on IPC.
My lord, there has to be an independent inquiry against me, my lord, by the disciplinary authority.
Show
my lord.
cause first. Then they'll see whether they will start inquiry against you. Yes. And page Annexure 3. Yes,
Annexure 3
who's
is the
applying for the state? Nobody? Didn't serve notice?
My lord.
Then the same disease plaguing this council's panel lawyers don't know who's appearing in which case. Yes, heard MS Ardata.
Entering appearance.
Then counsel for the petitioner issue notice.
My lord, we have an interim prayer, my lord, for stay of the suspension, my lord. So, my lord, I'm praying if this matter can be taken up tomorrow, my lord.
Okay, another board, but no stay.
My lord, let it come up tomorrow, my lord.
Yes.
Item number 4.
On the prayer also due to the absence of a senior, this matter tomorrow.
My lords, before I give my submissions, my lord, there's an additional affidavit that has been filed in response to the rejoinder, my lord. There's no leave of filing this additional affidavit in reply to my rejoinder affidavit, my lord. I have not come across the order sheet, my lord, as the leave has been granted.
So disregard it.
Disregard is, yes, my lord. So additional affidavit cannot be done. Now, my lord, this is a case, my lord, where we are the engineers, my lord, who have
admission hearing today.
It is an admission hearing, my lord.
Yes. Yes.
We are the engineers, my lord, who have been working in the department, my lord, for about 18 to 19 years now, my lord. Now there was a advertisement, my lord, for recruitment or to the higher post, and the requirement was that 15 years of experience on a particular post. So, my lord, we have, since both of us are having that 15 years of experience, my lord, we applied. 3 of us applied. Now that original advertisement, my lord, was for unreserved. Internal candidate, departmental candidate, but unreserved, my lord. So all 3 scheduled tribe belonging to scheduled tribe, 2 from Arunachal, 1 from Assam, my lord. We 3 applied. One stood in a merit list, and he got a post, my lord. And 2 of us, merit number 2 and merit number 3, were not appointed, my lord. Subsequently, my lord.
When was that recruitment? When was the promotion done?
My lord, the first that advertisement that we have applied, my lord, was of 21st February 2025, my lord. That is at page annexure 1. Annexure 1.
This filled.
This is filled, my lord. Now, now this is for the general, my lord. How many vacancies are there? These are direct recruitment, my lord. Now, what we are concerned is, my lord, that is the executive training electrical, my lord. That is what we are concerned. Yes, yes. In this advertisement, my lord. There's a page 18, my lord.
Yes.
Page 18. This is what we are concerned with, my lord.
Executive trainer.
Executive trainer electrical. Electrical. This. Now the total seat.
Where is that? It's not here.
Page, well, button the column.
18 is only. Okay, not the chart.
No, not the chart, my lord. Yes.
Okay.
Yes. So, my lord will see 13 number of posts are there. 13 number. Now, out of these 13 number,
written 13.
my lord has got a page annexure 1.
Yes, page 18. Last full-time bachelor's degree in engineering technology. So. Then where is written 13 posts? Where do you get 13 posts vacant?
No, this I'm showing to my lord this the bottom. There's a column.
Where is it? Okay, yes.
So
13 posts unreserved 9, SC2, ST1, EWS1.
Yes. So my lord, now total post available was 13. So the 10% of this is always reserved for the departmental candidates, my lord.
Okay.
So how do we come to know that is from page 26, my lord.
So, and when this recruitment was done, you said that one person is appointed.
Yes.
That means 10%, one person you will give in.
Yes, 1%. So two of them in the select list. Second and third, which we are before, my lord.
No, but it's over. 10% will be around roughly. So out of 13 seats, you can't have 1.3 posts.
No, that is right, my lord. Now, my lord, after that, what happened, my lord? Now, the recruitment rules, my lord. I'll just show first the recruitment rules, my lord. What the recruitment rule says, the NEPCO recruitment rules, my lord. Now it is an admitted fact, my lord, in their affidavit in opposition. Before I show to my lord, I just want to submit is that it is their admission also in their affidavit that there was a merit list. A merit list was drawn where number 1 appointed, number 2 and 3 are not appointed because there's only one post
Only
now.
one post,
Yes. So now, my lord, now the recruitment, my lord, can you have a recruitment rules at 7.1 clause 4.
Yes.
It says, my lord, the selection committee will arrange the name of the selected candidates in order of merit, and the appointing authority will make appointment in that order. Unless for any special reasons to be recorded, it is found necessary to vary that order in any particular case. Panel of selected candidates kept in reserve, which normally shall not exceed 50% of the number of advertised vacancies, will remain alive for a period of 1 year. We are empaneled.
Yes.
This panel, the selected panel on the merit, should the validity of this life is for 1 year.
But it's a specific selection for 13 posts. Now, if the life is for 1 year, if that post is filled up, then the list is not acted upon any longer.
Now, my lord, now what happens now is, my lord, if my lord will see my affidavit, the rejoinder affidavit, I have explained here in my rejoinder affidavit. Paragraph 9 of my rejoinder affidavit.
So first, be clear.
Yes.
Are you seeking accommodation in a subsequent selection?
What I'm saying is that, my lord, there are, my lord, 50 to 52 posts, my lord. And this advertisement has come within a span of 1 year from my select list, my lord, within the span of 1 year. So there is 50 to 52 vacancies of this electrical. We are of 18 to 19 years of experience. Select list, we are number 2 and number 3, which means the vacancy is available now. Now, what did they do? Now they have curtailed down.
But have they said that against whether against future vacancies? The first selection 13 posts was limited 13 posts.
Yes.
And if 10% reserved for in-house candidates,
yes,
one person's already got.
Yes.
So the selection process is over.
That selection.
And if they have a subsequent advertisement for the other posts, then they'll be open to fresh selection again.
Yes, that is fine, my lord. That is fine. But this advertisement has come within a period of 6 months, my lord. So, my lord, what my grievance is, my lord. Now, what happened is that the second selection, the first was unreserved, where we were empaneled. The first unreserved. Now, the second in advertisement, what did they do is, my lord, they say that it is for 1 post for SC, 1 post for OBC, curtail the experience to 5 years. Curtail the experience to 5 years, which means that literally, my lord, we have been pushed out, ousted.
I don't know how you can support argument. And you see your rejoinder, what have you said?
Yes, my lord, rejoinder, my lord, paragraph 9, my lord. paragraph 9. It is, may I read, my lord?
Yes.
It is respectfully submitted that under the original recruitment process dated 21/2/2025, 14 vacancies existed for the post of executive trainee. Subsequently, by the advertisement dated 28/10/25, further 18 vacancies were notified, apart from 2 vacancies reserved for departmental internal candidates, thereby increasing total number of available vacancies 34 posts. Thereafter, another advertisement dated 14/5/2026, an additional 16 vacancies were advertised. Consequently, the records of the respondents themselves disclosed the existence of approximately 50 to 52 vacancies for the said post. The subsequent advertisement clearly demonstrates that a substantial number of vacancies continue to exist even after the preparation of the select list. In such circumstances, there was no rational, lawful, or administrative necessity to alter the eligibility criteria relating to experience while the select list remained alive and operative. The abrupt change in the criteria, despite the availability of the large number of vacancies, is arbitrary, unreasonable, devoid of any intelligible basis. The same gives rise to a legitimate apprehension that the respondents acted with the sole objective of depriving the petitioners and the rightful consideration for appointment. Such is ex facie discriminatory and constitute a violation of the guaranteed 14 and 16. So you already have the post. Then why are you ousting me by introducing a new criteria here? And that select list is still alive. And when the select list is still alive, now what did they say? Their only objective they're saying is that no, we don't have a panel. We are not a panel, and that advertisement is over, selection is over, but the vacancies is there.
Yes.
So if the vacancies is there,
yes.
Do we don't have an legitimate expectations? Having put for almost 20 years in the service. So what happens now, my lord? My juniors, all my juniors will be superseding me. So that is not fair. We cannot say the fairness in the recruitment act. So I am only seeking for this protection, my lord. They can consider my list is there, my experience is there.
The second advertisement was 28 or 23rd.
The second advertisement, my lord, I have
mentioned that in a paragraph.
Yes, that is here, my lord.
Now you said the second one advertised only one OBC and one SC.
One OBC, one SC. But the first one, then if that be the case also, then when did you reserve for the ST? Because the first advertisement of February was an unreserved. Just because in an unreserved category, one ST got, you cannot stretch and say that now since one ST is filled up, we will give to others.
So the thing is that this post cannot be filled up. That's why they relaxed the criteria for this OBC and for the SC post.
Now, my lord, when
internal candidates.
That cannot be also, my lord. That will go against their own rules, their own policy. Why they say that if any internal candidate who does not have that requisite experience and qualification, they can appear as a direct recruit.
Yes.
They can appear. That is. So therefore, my lord, it was not necessary for you to relax just to fit in somebody, because if somebody is interested, even if an internal candidate.
But the second advertisement was not for unreserved. It was for.
That is the problem now. That is a problem.
How can we force them?
No, we are not asking to force them, my lord. Because now even unreserved candidates, my lord, 50 to 52 seats are still there, my lord. 50 to 50 seats vacant still there, not filled out.
Yes.
It is there, my lord.
So if their stand will be that there was during that time as per the merit list they filled up.
They filled up. Yes. This is what I'm saying. They filled up, but the vacancy is still available.
But the other vacancies which is advertised as for OBC and for scheduled caste and which don't fit.
I won't fit. That is exactly the tactic. Can you look at the tactics, my lord? In order to oust. In order to oust me, my lord. First of all, in the unreserved seat. No, till now, my lord, for the scheduled tribe, reserved seats have not come up. They have not advertised. The first was unreserved. Now the second advertisement, they curtailed down immediately the experience of years, and they gave it to OBC and SC. I'm not against that, but because they're saying that if you don't have that experience, you can appear direct as a direct recruit. There's no bar. So by doing so now, my lord, you have completely ousted my chance. This is what we have agreed with, and this is against the known fairness in service recruitment, my lord. Even the promotion matter, my lord.
Where is circular? Which you have challenged? It's in a prayer.
Oh, yes, my lord. That is. That is page NHR 5, my lord. NHR 5. NHR 5. NHR 5 the read petitions. NHR 5 of the read petition. This one.
This is the second advertisement.
This is a second advertisement.
But it's on 23rd.
This is the 23rd October 2025, my lord.
Yes. Yes, 15 years.
Yes, and 15 years, then the corrigendum, my lord. Now the corrigendum is 19th November.
Yes.
Corrigendum. This is what we are agreed with, my lord. Can you look the experience requirement revised? The clause experience 15 years experience NEPCO may please be read as 5 years. 5 years. So, my lord, today, since it's for admission, let it get admitted, my lord.
Yes,
a few citations are there. I will let it come next week, my lord. We'll finish it on next week because few citations are there, my lord.
To finish now.
No, this is
anyway, let him finish. I'll make this.
It's finished, yes.
Yeah.
Finish.
No, this is admission hearing for the
Yes.
So, your lordship, I'll just one more. A list of date is prepared for the convenience of the court. Your lordship, first I'll take to his prayer. Prayer is at page number 11 of the writ petition.
Yes.
He wants two things. First thing is that issue a writ of certiorari quashing the impugned circular dated 23rd October 2025 and corrigendum dated 19/11/25, reducing the experience requirement from 15 years to 5 years. That is one prayer. Issue a writ of mandamus directing the respondent to consider and appoint the petitioner to the post of executive trainee E2 grade.
Yes.
Based on the impanelment arising from the interview held on 3/6/25. That is, he doesn't want his grievances is only with regard to the first interview for your category,
understood,
for which we have already appointed a person.
That's the first question.
Your lordship,
if the selection process
no,
deemed to be over,
no,
then
your lordship will come page 8, paragraph 11 of the writ petition.
Yes.
What is his statement made in the application? That instead of filling up the post from the impaneled candidate, the respondent issued fresh circulars and corrigendum altering the eligibility criteria. He makes a false statement here that instead of filling up the post, we have made
a fresh
issued the circular, and which in the submissions he is telling that appointment was made, but in the writ petition on the affidavit he states that that post is not filled up. In any event of the matter, your lordship, that in the advertisement the first advertisement at page 18, the requirement was graduate aptitude test in engineering qualification. Under the qualification, graduate aptitude test in engineering.
Yes.
Now, Your Lordship, the board has taken a regulations at Annexure 3, page 22. Your Lordship will see my affidavit in opposition. Affidavit in opposition. Page 22, and I am drawing the attention of my lord to page 26. The board deliberated the matter as recommended by the Nomination and Remuneration Committee and approved the proposal for inclusion of all discipline for reservation of 10% vacancies in E2, E3 and exemption of score of national level test as eligibility criteria for absorption of departmental candidate in induction level post in various disciplines, provided that the candidate has rendered at least 15 years of experience as NIPCO employees for all the discipline or for technical post. Further, a written examination may be conducted by an external agency for the reserved position of internal candidate, followed by interview. In case there is no written examination, the criteria, the interview panel shall be constituted with the presence of at least one functional director. So, by this regulation, Your Lordship, we have done away with the required qualification of the graduate test, which was essentials, so that the internal candidate, because they will not have like CRAT or any specialized, so we have done away. Then thereafter, Your Lordship, we have issued the circular by which one vacancy for UR candidate from the UR quota was reserved for, and so far the unreserved categories are concerned, Your Lordship, anybody can apply.
Yes.
Even SC, ST can apply.
This resolution was which date?
And second advertisement,
No,
Your
this
Lordship.
resolution was which dated when?
Which one, sir?
This resolution you read just now was.
Regulation is dated 10/8/24. My serial number 3 on the list of date.
10. Okay.
10/8/24.
Okay. Yes.
And then thereafter, Your Lordship, we have issued the internal circular for which the interview was held and the selection test was carried out. Your Lordship, this statement I have made in my affidavit. Your Lordship will come to page 6 of my affidavit, Roman 5, subpara Roman 5, page 6.
Yes.
In order to fill up one UR of executive trainee, Your Lordship, I may explain one thing more, Your Lordship. These appointments are for executive trainee under the special scheme.
Trainee or engineers?
Engineers of different disciplines we have. This is a new scheme which is introduced, by which what happens, we take the recruitment and send them for training for 1 year at the cost of the corporations, and they get qualified there, and thereafter they are posted. It's not a general type of appointments. These are under a special scheme sponsored by the government of India, and we implement that scheme so that many people get
So this
the chance.
selection and this is only limited to internal candidates.
Not the internal candidate. Direct also we take.
Okay.
But for direct candidate, that aptitude test is needed. And that for that test, because that test was there, internal candidate were not in a position to apply because nobody used to have this type of specialized test here. So therefore, this was done away with. Now I was reading paragraph 5. In order to fill up 1 UR of executive trainee from amongst the eligible and willing departmental candidate, an internal circular was issued wide memo number so and so dated 17/3/2025, enclosed as Annexure 2 to the writ petition and was widely circulated to the plants. Then I come to in response to the said circular, 4 number of applications were received through proper channel for the post of executive trainee, including the application of both the writ petitioners. On prima facie administrative scrutiny of the documents submitted by the candidate, it was found that only 3 candidates are eligible for 1 UR vacancy. The administrative scrutiny has been done purely as per the circular dated 17/3/25 and the relevant rules enforced at the relevant time. As decided by the competent authority, all the eligible candidates were called for offline interview for the post of executive trainee, which was conducted on so and so at corporate office Shillong. A selection committee was constituted by the competent authority. Then I come to number 7, Your Lordship. The selection committee, after having assessed the suitability of the candidate based on the performance during the interview, recommended the following candidate in order of merit to be appointed as executive trainee against 1 UR vacancy which was approved by the competent authority. So we have given Your Lordship the select list or the merit list at page 8. Now petitioner number 1 and 2, they appeared at serial number 2 and 3.
Only one thing you have to make clear to the court is that this selection for which they had qualified is limited only to that circular only.
That circular only.
Ended there only.
That circular.
And so they cannot derive any vested right by saying that since we are in the panel, as number 2 or number 3.
Panel,
now, exactly, that is what you have to satisfy the court. That is not a panel, that this selection was specific only for that 1 UR post.
Yes.
And there was, they had applied and 1 person was appointed, so that list is dead, and that in the event only this number 1 are joining, then consideration will come.
Yes.
But
number 1 has joined.
Yes, it's an independent selection process, not connected to the other circles yet.
Definitely.
That's only what you have to, if that is your case, then they have no case.
No, Your Lordship will see page 25 of the writ petitions.
Yes.
Page 25, that circular. The
right can't survive to another section.
For other posts, because we have to advertise that post.
Yes, where is that?
Page 25 of the writ petition.
Yes. Yes.
This is in order to fill up 1 post, UR1 of executive trainee. It is specifically mentioned in the circular that it is for 1 post, and when that post is filled up, the matter is ended. I will just
play. Second submission
Your Lordship, I will place the Constitution Bench judgment, latest judgment on this point. Your Lordship will just see 2025 2 SCC.
2025 2 SCC.
2 SCC, page 1. Paragraph 22.
Has you given the list of books to the petitioner's counsel?
We have given, sir. Only one citation. Para 22.
Yes.
The process of recruitment, this is Your Lordship 5 judge bench. The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. It consists of various steps like inviting application, scrutiny of application, rejection of defective application, or elimination of ineligible candidate, conducting examination, calling for interview, etc., etc., Your Lordship. Now, let me just take to Your Lordship the second circular. Second circular is dated 23rd October, page 31.
Yes.
Applications are invited from eligible and willing departmental candidates for filling up the following post: 2. Post of executive trainee, electrical mechanical, OBC 1, SC 1. My friend does not belong to either OBC or SC. He is a scheduled tribe. As a matter of fact, Your Lordship, this is as per the roster. It's not that arbitrary. We have to maintain a roster, and this is, Your Lordship, in addition to the normal reservation provided. Now 10%, whatever the posts are executive.
We kept inter-departmental candidates.
Yes, it is kept for the departmental candidate, so that they get it. And it is on a rotation basis. Rotation. We have to maintain their roster as per the guidelines of the Government of India. Yes. Now, he is not even entitled, but he has applied for this post. And what has happened? These two persons have applied. No, they were not from the required.
No, were the applications accepted?
No, it is accepted. It is accepted for the reason, Your Lordship, that what happens, supposing there is no candidate found suitable for OBC and SC category, then the position is this, that if there is anybody found selected from the ST category, he is appointed, but he has to face the interview. His application is accepted. He is making a submission that he is debarred from appearing. No, he is not debarred, but he has to undergo the selection process. And if his luck favors and nobody is found suitable from OBC or SC category, then definitely he may be selected or recommended.
Okay. Yes.
That is the position, Your Lordship. Now, another point, Your Lordship, which he was making,
the
amendment
of experience. Yes.
Experience. I am just clarifying that, Your Lordship. Your Lordship, that this second advertisement was for OBC and SC category. Now the last date of submission of the application was 3rd November 2025. Your Lordship will just have a note on this, that 3rd November 25 was the
yes.
Now, Your Lordship, before this date, the Board of Director, Your Lordship will just see.
They had a past resolution whereby the experience requirement was lowered from 15 to 5 years.
Yes, yes, Lordship. Then come to Your Lordship, my page 30 of my affidavit. Affidavit in opposition. This is the extract. This is the extract of and this is dated, Your Lordship, 15/9/2025. I have just taken the extract. Now, at serial number 5, Your Lordship will find
only such NIPO employees.
Only such NIPO employees are eligible to apply as departmental candidate who have completed minimum of 5 years of service in NIPO on the last date of online registrations. However, employees who have less than 5 years of service in NIPO can apply as external candidate. Your Lordship, before this advertisement was done, the board has already taken a regulation. It's not that after this advertisement, the board has already taken a regulations, because no application of OBC and SC could be received because of the requirement of 15 years. And these two persons have applied, and they were not from the OBC and SC category. But however, we cannot.
That's why he's saying that if the policy is such that if an ST candidate applies, and in the absence of any SC or OBC candidate being available, then naturally appointment will come on them. So yes, that's what he's seeking to maintain his right. That now, in order to oust them, since they would be the only ones at 15 years, so he have reduced the qualification to 5 years. But was this? But this corrigendum was arrived at was a resolution was taken which date 10/8/24.
Which one,
was
Lordship?
taken on the resolution.
This regulation was taken on 15/9/2025.
The resolution to reduce the qualification, the experience.
Experience.
Yes, and then.
And then, Your Lordship, this regulation, board regulation, though it was taken on 15/9/25, but it was notified only on 24/10/25.
Within 1 month.
It was notified. Now, Your Lordship, that in order to give a chance to the OBC and SC category, and to have a broader
with a policy where if that they even if the post advertised for only for OBC and SC, they'll be eligible to apply, and in the event that there's no
yes, Your Lordship, there is no such written administrative instruction.
Then how do you
no, Your Lordship, but he himself has stated, and we have admitted this fact, that
admitted for hearing.
There are
admitted for hearing. We have to now, if that is the case, then there's something. I thought that there was nothing.
No, Your Lordship, what is their prayer and what is their right? What right they had derived from this? They are not even OBC and SC category.
No, but see, the thing is that if they are totally ousted from even crossing,
no, they are not ousted.
Even crossing the threshold. Exactly, you're not ousted them from the threshold. Now,
Your Lordship,
as per now to challenge. See, one thing they've done, Mr. General, please try to understand, is that they've challenged the corrigendum also, lowering the experience criteria, by which it is open to field to. So that's one thing which court examine. Whether that decision, we cannot interfere in policy decision, but we have to go to the decision making process. Whether arriving at that decision to reach experience, it was by which, on what circumstances.
Your Lordship, I have already explained in my affidavit.
We heard.
I have already explained in.
Matter stands admitted. We have it next week. Matter stands admitted for full hearing. This matter after 1 week.
After 1 week. Yes. My application for Your Lordship is still pending. 226(3).
This heard. Application for evocation at this stage has been considered heard and dismissed. Yes,
my lord. Much obliged.
Yes, that is case. Then we have to look at it. If that is the policy. I thought that they're all independent selection processes, but if they challenge the corrigendum,
Your Lordship, I am telling there is no policy.
Now you see there's a policy. You see, admitted it.
It is for the selection board.
Obliged.
It is for the selection board.
We will examine. Interesting case. Yes. Who's bringing 6 and 7?
Lordship, I've been instructed that respondent number 7 has accepted accepted the notice. However, the respondent number 6 has refused to.
Mr. Paske appearing for 7 and 8.
Only 8.
Only 8.
Your Lordship, I am appearing for respondent 8.
Now, where's affidavit?
I have not bound record.
Mr. Lasongluya today submits that the notice has since been served on respondent number 7. However, respondent 6 has refused. He prays about to bring affidavit on record on this fact is. And yes, what do you want? Yes.
I'm appearing for the state, my lord.
Yes.
5. I'm appearing on behalf of the state.
Yes. What do you want? Have you filed affidavit?
My lord.
They filed the affidavit.
Only 5. What about number 8? Mr. Paske.
Yes, filed.
Already filed, Your Lordship.
List after 2 weeks.
Your Lordship, this matter was heard at length.
Yes.
6.
Yes.
Your Lordship.
Proceedings are complete. Rejoinder has been filed, my lord.
Come for hearing.
It's a short matter or long matter? Medium.
Medium next week, my lord.
Yes, the party submitted appeals a complete list for hearing.
7.
My lord, affidavit from respondent number 1 to 4 is yet to be filed, otherwise
1 to 4 is not filed, why? See, not filed?
Lordship, I'll be.
Have you filed a joinder to the other affidavits?
My lord.
Well, please allow 2 weeks time for your affidavit file. Who's 5, 6 and 7?
State, Lordship.
State.
Lordship.
I have filed the affidavit, Lordship.
So what about
3, Lordship. I'm praying for some time before the next.
Why?
I'll be filing, Your Lordship.
Who's appearing? You're appearing for 3. What about the other respondents? 5? Who's 5?
5 is the chief engineer.
Not required.
I have filed. No, 5, 6 and 7 I have filed, Lordship. And these respondent 2, 3 and 4 are not required, Lordship.
Okay.
Because these are finance department.
3.
3, I'm for 3, Lordship.
But in the course of the day?
No, Lordship, I'll be filing, Lordship. I'm yet to get to receive the signature, Lordship.
Yes, I mean, we last opportunity.
Lordship.
Place 4 and allowed last opportunity to file affidavit on behalf of number 3. List after 2 weeks, yes.
8. 8.
Please, your lordships.
The state has already filed the affidavit, your lordship.
What about 1, 2, 5, 6 and 9? State.
State we have filed.
That's 1, 2, 5, 6 and 9.
Yes,
I'm for 9, your lordship.
filed by respondent number 3.
I'm for 9.
Who haven't filed? Or filed? Who has filed? Mr. Sumkani appearing for 1, 2, 3, 5 and 6.
Yes, sir.
Who's Abhinavrum for 4? S. Dev for 7.
Yes, we have filed, ma'am.
Emalongpur for 9.
For 9.
You're for 8. Who's 8?
The district
No,
council.
who's 8?
District council, yeah.
So what for today?
For lordship, I'm filing the affidavit on respondent number 9 in the course of the day. Lordship, today, sir.
I'm praying for rejoinder on all the affidavits, your lordship.
Yes, Mr. Emal Nongpur submits that affidavit behalf of number 9 will be filed in the course of the day. What's your name? MSL Mirchiang. Mirchiang. On behalf of number 8 submits that no affidavit forthcoming from the respondent. Accordingly, all affidavits are on board from the respondent stop. Next paragraph, Mr. Pasanthi brief was allowed how much time?
3 weeks time, your
3
lordship.
weeks time?
3 weeks time.
3 weeks time for rejoinder since they are separate affidavits. List of 3 weeks for rejoinder.
Lordship.
9.
Yes, Mr. Pandey.
Lordship will file rejoinder on this, Lordship. Petitioner's contention is that by virtue of being the spouse of the deceased government servant, she is entitled to family pension, Lordship. On that, will file a short rejoinder, Lordship.
Yes, Mr. Pandey, counsel praise for and allowed 2 weeks time to file rejoinder. Yes.
Must always, Lordship.
10.
10 is for affidavit, I'm praying for some more time.
How much time? This one has been.
We've sent for signature, it doesn't.
Yes?
Sent for signature, it has not come.
This is the last order.
Yes, please.
Dr. Enmo's Calendar I with so-and-so submits the due to inadvertence. Yes, due to inadvertent circumstances, the applicant will reply today. He preserves 1 week for the time. Yes, just after 1 week. Yes, we'll record your name. It's B. Sarma.
Deeply.
B. Sharma.
Deeply
SCR.
authorized.
11.
Please, Your Lordship, the pleadings are completed, Your Lordship. It may be posted to hearing, Your Lordship. Yes, yes, Your Lordship. The Forest Department has encroached the line of the petitioner in this matter, Your Lordship.
We will be relying on the affidavit filed by the state. Yes, MST and Maraf admits that these submissions are complete only this matter for hearing after 2 weeks.
12.
May I please, Lordship? But my respondent have filed a affidavit in opposition. I will file a rejoinder, my lord. So sometime I will file rejoinder, my lord, against the affidavit in opposition.
So file affidavit.
2 weeks time must be allowed for joinder. Yes, there are done so.
13.
Last time, Chirwa, you said wait, the matter be called out again, you disappeared.
The moment I came, I apologize, Your Lordship.
Yes.
But substantially, it has been complied with that.
Yes.
Not exactly, my lord. Because the
three directions, my lord.
Inquiry report till date we have not received, my lord.
And the OTS says supply for December 2025.
No, my lord.
The incident orders issued so and so. You take instructions, is that correct?
Yes, my lord. Yes, my lord.
How is it possible? We can't
we have received a bunch of the documents, but not the inquiry report. Before the learned single judge, also the inquiry report was not furnished, my lord. Entire record was placed before the single judge, my lord.
Dr. N. Mosika, learned DSGI, so produced a communication dated 22 May 2026, which he submits which is full compliance with the orders of this court. Stop, Mr. El Karim, Counsel Pish, however, has submitted that the inquiry report, which is stated in the communication, have been supplied to the petitioner on 4th December 2025 is incorrect, as they are yet to receive the same. Parties to obtain instructions just after 2 weeks. Copy to communication dated 22/26 is taken on board and made part of the record.
14.
The 14 also for affidavit.
Yes.
Some more time.
Both for the petitioner.
And for the petitioner, Your Lordship.
Yes, Dr. Mosika also responds allowed for the 2 weeks time for affidavits.
I'm like, Your Lordship.
15.
May please, Your Lordship. We filed the rejoinder, Your Lordship. The pleadings are complete. May it come up for hearing, Your Lordship.
Is that regarding this stall?
Yes, Your Lordship.
Well, I have also prayed to file a small objection to their miscase. So I have filed it today. We'll be serving them a copy.
There's no interim prayer. There's no interim order.
No, there is no interim order.
Then?
Subsequently, they have filed a miscase.
Yes.
Subsequently, to stay the demolition method. Against that, we have prayed, and court has allowed us.
Yes, where's the miscases here?
Yes, miscase is there, my lord.
Which miscase? I miscase.
148.
148. So
148.
Mr. S. D. Prays for further. How much time?
Well, I will be filing it today, my lord. Course of the day.
Submits the affidavit objection to the Mrs. application. We find the course of the day. In the main case, MS Karmana submits the claims are complete. This is a matter after 2 weeks for hearing, along with the miscase.
Yes.
16.
To land acquisition, my lord, the petitioners are alleging some encroachment, my lord.
counter was ready, my lord, but certain vital informations were missing. So then, my lord, I need some more time, 1 week time. We will file within 1 week. I have reviewed the counter, but there was some shortcomings in the counter, my lord. So kindly give me 1 week time.
In these connected matters and affairs general, praise the allowed 1 week for the time to finalize the affidavits file.
Respondent number 5 has filed.
Already filed, Lordship. And it's
6.
Respondent number 5.
It's the and 6. 6 is a contractor, my lord. We have notice have been received. We have filed an affidavit to that effect also.
Yes, sir. On behalf of Tommy, on behalf of the respondents number. On behalf of state respondents, state respondents submits that the praise for further 1 week's time to file affidavit, to file the affidavits which have to be finalized up. With regard to NHIDCL, number 5, Mr. S. Pandey submits the affidavit already on board. Stop, Mr. You filed service affidavit?
Yes, my lord. We have filed since 3rd of March, my lord.
Yes, though the service is complete on the respondent number 6,
my lord.
And there's yet no appearance on their behalf. So list after 2 weeks for affidavit and for appearance of respondent number 6.
6, my lord. Much over.
21.
Please, your lordship. Lordship is a matter pertaining to compulsory retirement.
Who compassion to?
Pertaining to compulsory retirement.
Lordship,
So they have
I
to
will
file.
receive instruction, Your Lordship. I'll be filing.
What for the state? Nobody.
Zadeen
uncle.
None appears for the state. MSB Pasa for. Yes, Mr. G and Rinja for son to 5 and 7. You file affidavit.
No, my lord. It will take some time, my lord.
E for 6, brief one out for 2 weeks time.
Much out.
22.
Item number 22 to 29 are similar except 26, my lord. Matters pertains to the selection and appointment in Assam Rifle, my lord. Affidavit in opposition has not yet filed, my lord.
22, 20, except 26.
22 except 26, my lord.
Yes. That means 22 to 25 and 27
to
29. Yes.
I'm praying some more time.
My lord.
These items as prayed further 2 weeks time allowed. 25 to 20. Also 22 to 25 and 27 to 29. Yeah, 26.
Yeah, interim may be continue, my lord. There is
interim orders. If they shall continue. Yeah, 26.
And 26, my lord, pertains to promotion matter, my lord. But affidavit in opposition is still awaited, my lord.
I have instructions to appear for the respondent for.
You may attend it. Was the first time it's come? Oh, no.
No.
Mr. ML Numpur to raise under appearance on behalf of respondent 4 as such service complete on all the respondents. Dr. Mosika put and
for affidavit.
Praise for further 2 weeks time to file affidavit. Similar prayer made by ML Numpur list after 2 weeks or 3 weeks.
My lord. DPR lordship.
30.
So this is for affidavits.
My lord, I'm appearing for respondent 1 to 3. I'm awaiting for instructions. As soon as I get instructions, I'll be filing my affidavit. I'm appearing on behalf of respondent number 5.
For the 5 not served.
5 minutes.
Yes.
I'll take fresh steps.
You'll file affidavit? No. Yes or no?
You'll file instructions.
You'll file.
I'll seek instructions.
Instructions whether you have not examined the petition.
I've examined, will be filing.
Then you're appearing for KHDC.
Yes, my lord.
How
1
many
to 3
lawyers KHDC have? What is the matter about?
My lord, this is about boundary dispute.
Lordship.
Boundary dispute
Between the
from
petitioner and respondent.
parent village and the child village.
MSOAI Bank 123.
Yes, my lord.
MS meeting law for number 4. They found out for the 2 weeks time file affidavit stop. With regard to respondent number 5, Ms. Priya is allowed to take fresh steps.
Lordships, because the order says, I'll just verify from the post office, Lordships.
With regard to Mr. Emmanuel Priya is allowed to obtain status and file affidavit.
Lordships.
Yes, after 2 weeks.
31.
It's for affidavit. I'm praying for some more time.
With 3 weeks time has played a lot for affidavit. Yes.
32.
Does that matter again?
Yes, my lord. This case, my lord, hearing, my lord, we have already filed, we have given, my lord, 48 hours time to file affidavit. We have filed the affidavit. And my lord, matter is coming up for hearing again tomorrow. In fact, it was substantially heard. And it is before the other court, my lord. And so far this case is concerned, my lord, I have filed, this being a court of record, my lord, I have filed an affidavit also, your lordships, saying that the matters are same in the other matter also. So, my lord,
the stand of the district council is different. Your lordships, if I may just hand over the affidavit filed by the district council.
They file it here. This one file here.
No, in the other court, their stand is something else. That this issue cannot be raised in that matter because it's pending before this matter. Can you just have the paragraph 12?
Is that correct, Mr. Sen?
No. Same.
No?
Same impugned order challenge here.
No.
Same order.
Same
impugned
order.
order change.
Moreover, this is in the other matter.
Why? Then why have you made it overment?
So their stand in the other matter is because this matter is pending, that issue cannot be taken up by the other court. That is the stand of the district council. This is their affidavit, my lord.
See, Mr. Sen.
This is filed by the district council.
No. This is not my affidavit. I have not.
District council's affidavit. 12.
Para 12, the last part, Mr. Changreso.
Last part.
Last.
No, not this affidavit. File in the other case.
Which case is in? There's a case pending before Justice Dingdo's court.
Yes, my lord.
Nothing happened that day.
But the other side saw time for filing required.
Is it over the hearing?
But
Yes, my lord, hearing.
Hearing.
But this is the official stand.
No, hearing is not over, my lord. In fact, my lord, initially there was a substantial hearing, your lordships. After
But Mr. Changreso, you kindly see this one. Moreover, is placed on record that as the issue as to whether Period Deputy CM has the right to be appointed acting chief is one of the issue in WBC number 2, which is filed by him, also which is pending under consideration. Hence, the incident petitioner has no locus to press the same issue for his court.
Correct. This is their stand.
then it is the same issue then. Same impugned order.
No. Then you're saying out there he cannot press for stay of impugned order.
My lord,
and here you're saying that here you're saying this court cannot take it up because the other matter which waiting hearing. So what is the stand?
My colleague, my lord, the present petition is not that good, that side. So other petition is
Please make the court understand. Because now what you're saying now, see, we're accepting some. We didn't take it up. It's okay, fine. Since we're contemplating sending it there. Now, if you say that don't take up the matter there, because this matter is it's here in WC number 2.
332.
No, this number. What is this WC number 2?
332.
No, what is WC number 2? Have a look, Mrs. Sen. You have to assess the phone.
My lord, I have taken.
No, you're not in the picture here. The thing is that now, see the submission. WC number 2 is what?
332, my lord. I meant.
Where's this WC number 2? See, Mr. Changreso. Will you give to them? It's very confusing.
WBC number 232, my lord.
After see this one, he's given us 2.
He has it here.
My lord, that is
what is your stand, Mr. So can you tell us what is this council stand? We just want to know.
My lord, the stand of the council is, my lord, the impugned order, the challenge here
it was similarly challenged her side, other side. So we say that this issue challenging this court before that honorable court is also part of the issue already pending here. So that was the appraisal, my lord. We appraised.
No, but then you say, then you tell the court he has no locus to press the case there because of this case here. Now, so where does that leave us then? So you're saying you're sort of telling the court, no, don't take up the matter. He can't press because he has no locus to press because the matter is pending here. But it's the same impugned order.
Same impugned order. Same impugned order.
Just two parts. What they are saying is two part, very straight. Two part. Now, virtually, what is happening, my lord? One part, lordship is called.
I've never, even as a lawyer or as I think as a judge, I've not seen this kind of situation.
But in my affidavit, your lordship will see kindly. My affidavit, I said
you're a beneficiary, but I mean this stand I have not seen this kind.
What I said, it needs to be tagged together.
Here they're saying something else.
Tagging together is a different thing. Yes. But if you say something else there that because of this you can't do this, and that could you say because of that you can't do this. So how, Mr. Chamiso? How we reconcile? Even if tagged together, then?
If we take together, my lord, that is another case, my lord. Otherwise, admittedly, my lord, other mathematics for final hearing tomorrow.
Everything stands resolved, your lordship, my lord, if we tag this matter with the other case.
No. And the court wants to understand. We are willing to tag it also, right? But they have serious, they think that this is independence filed before. Court has to accept the submission also, right? It's filed before that other case. So whether tagging of cases happens always when, a case is subsequently filed and to an earlier case. That is the convention and the propriety demands that. Now that is a stand, so we accepted that. Now if you go and make another submission there, then what's the court to do? You give the solution.
But we just pray for, if we taken up all the duties, let the other side decide and let the fix for him. But
my lord, I am on my own cause. I am on my own cause.
The same,
this merit petition is before
this kind of vermin is
this is something very strange. Another thing, my lord, there is an impression, my lord. I feel very sorry, my lord. There is an impression, my lord. I want to take out this case from here. It is not like this, my lord.
That impression.
My lord, I cannot. No, my lord. It's only the client, my lord. When the client came and said, "Here's an apprehension," I say, "How you have an apprehension? I cannot make a submission." Then I examined, my lord. Then I found, my lord, the same decision two part. No, one part, entire part.
But the thing is that, can you make this kind of thing in other court also?
I have not made. I have not made.
You're trying to preclude both courts, that matter should not be heard at all.
That cannot be.
That's what it means.
Not press. But this part we will not press before that court because he has heard the matter.
They are filed on affidavit, my lord.
Same word.
I'm concerned with my case, my lord.
I understand.
I'm concerned with my case. I have my own cause, my lord, to fight.
Really, I don't think Mr. Sen's faces this kind of situation also, the council.
I think
so the skill of advocacy should go to you or should go to whom?
Fitness of the thing, my lord. He also got an opportunity. Same issue is there, my lord. Tag it.
My lord, I'll just place some judgments, my lord. Compilation.
But this vermin is. We're prepared to actually. Yes.
So, my lord, the first point I'm raising is, my lord.
No, Mr. Already the court indicated because any order cannot supersede the statute.
Correct, Lord. Correct.
So if the statute provides for such that unless there are very other compelling reasons, the reason that's given will not suffice to defeat what is the.
So, my lord, the judgments based on the principles of Taylor versus Taylor, my lord. So that is very clear, my lord. If the statute provides something, it has to be done in that manner, my lord, and not otherwise.
Just we'll do one thing.
End of the board, my lord. End of the board.
End of the board. Let's see. That's very.
Hearing 35.
Yes, what's the matter? What's the matter about? Yes.
Has directed to file representation against the adverse remark, my lord. That representation has been rejected, my lord. on only mechanically grounds, my lord.
Where's the rejection?
Rejection, my lord. I have submitted a separate order, my lord. Impugn order, my lord.
Is that annexed petition?
Annexure, actually, my lord, what happened, annexure was not legible. That's why I am submitted.
Okay.
I have submitted.
Oh, yes,
my
annexure 10, page 32. Yes. Yes. Where?
Yes,
why
my
is he? Why is he not speaking?
My lord, speaking order, page number 3, my lord, paragraph number 9.
Yes.
That
Yes.
is C, come to C, my lord.
Yes.
On perusal of annual confidential report of the petitioner for the year 1415 to 1819, it is revealed that the petitioner has been graded high average.
Click I-25, I think. Oh, which kata I wrote in, huh? Otherwise, it's getting warmer or something. Yes. Yes. Yes, please continue. Sorry.
My lord, my lord. 1819, it is revealed that petitioner has been graded high average 5 points in the ACR for the year 1415 to 1819. Assessment and grading awarded in the ACR by initiating officer and reviewing officer are purely based on the performance of ratee during the assessment period, my lord. Hence, award of 5 points grading during the assessment year for the year 1415 to 1819 are clearly lacking the required ACR criteria. Hence, the petitioner was rightly denied the promotion to the next higher rank of Subedar GD by duly constituted DPC during the year 2020. Next, my lord, D, in the vote mentioned that petitioner was assessed in his ACR by 7 different officers during the year from 1415 to 1819. High average grading in the continuous period from the year 1415 to 1819 clearly reflects that performance of petitioner was not up to the mark for considering him for the next rank, my lord. That is the specially reason for rejection that 7 officers has been assessed the petitioners, my lord.
Yes, what's your case?
My lord, kindly come to my read petition, my lord, page number 41, annexure 12, my lord. That is the office memorandum, my lord.
Yes.
Below benchmark grading in ACR prior to the reporting period 8-9 and objective consideration of representation by the competent authority against remarks in the upper or for upgradation of the final grading, my lord. My lord, come to paragraph number 2, my lord.
Yes.
As per existing instructions, representation against the remarks or for upgradation of final grading given in the upper known as ACR should be examined by the competent authority in consultation, if necessary, with the reporting and reviewing officer, if any. While considering the representation, the competent authority decides the matter objectively in a quasi-judicial manner on the basis of the material placed before it. This would imply that the competent authority shall take into account the contention of the officer.
So your only contention is that did not give specific reasons.
My lord, and my lord has passed the similar order in this issue, my lord, a second time, my lord. That is WPC number 83 of 2024, my lord. My lord has directed the respondent authority to reassess the representation of the petitioner, my lord. This writ petition is also the second round of litigation, my lord. So my simple prayer, my lord, that my representation may be reconsidered, my lord, on that basis, my lord.
This judgment is, in my bosom, is not relevant.
You took in consideration other irrelevant years.
Yes, ma'am. Para 6 you lots policy on it. The ACR of 2007 and 8 were taken into consideration, where the period under consideration should have been 16 to 21. That's why lots have said that the 7-8 cannot be taken into consideration. Assessment year 14-15 also found place in this.
Yes.
My lord, kindly see. Page
Now,
my lord.
Let's see the order. Let's see this court order first, directing for.
My lord, that is writ petition, page number 24, annexure 8, my lord. And relevant portion is page number 26, my lord. In this view, the matter, the writ petition is disposed of with the following direction, my lord. Page number 26, my lord.
Yes.
May I read, my lord?
Yes.
The respondent authorities are directed to formally communicate all the 5 entries made in the ACR for the assessment year 14 to 19 to enable the petitioner to make a representation within a period of 1 month of receipt of the communication thereof. The representation so presented will thereafter be decided positively within a period of 2 months in accordance with law. It is further directed that should be entry be upgraded in consideration of the representation taking into account the petitioner's earlier track record. The respondent authority shall constitute a review DPC for grant of consequential reliefs, if any, on the basis of the above. The entire exercise shall be completed within a period of 6 months.
Yeah, Dr. Mazika.
Yes. I want to present to the directions, my lord.
For 11 years.
My lord, ACR was communicated to him. He submitted.
2014-19, 5 years. Yeah, then.
But here, what happened? My lord, he is lacking in criteria. Lots of kindly sees. But only one important aspect here. Lots of kindly sees my affidavit, my lord. For a moment, right? Yes, sure.
Yes.
Subpara D.
Yes.
That in paragraph so and so 7th Central Pay Commission dated 25/7/16, it was recommended the benchmark for promotion be enhanced from good to very good. The same has been accepted. Government of India, Ministry of Personnel so and so, dated so and so. The EBIT policy has been implemented in the Assam Rifles with effect from 1/1/16 for grant of promotion in MSCP scheme benefit by directed number so and so so and so. as per the revised policy, minimum 7 points required, which was earlier 5 points, my lord, with effect from 1/1/2016. And the relevant period is 14-15 to 18-19, my lord. And because he had 5 points only in all the, now upgradation can otherwise also for one particular year, my lord, that can be upgraded. Here is throughout, my lord, he has 5 points.
5 years.
5 points, my lord. Yes, my lord.
Yes, Mr. Kumar. That case is
my lord, 5 years is 5-year ACR, my lord, but the ACR has not been communicated to me, my lord. That's why I was.
No, but now you're given a chance to represent, and now they've re-examined it against the provident policy, and so that you're not eligible for promotion.
But they have.
If you scored 5 only,
my lord.
Then.
But they have rejected my representation mechanically, not.
No, there's no mechanical rejection. Only thing is that maybe you might have a point with whether those reporting initiating officers were consulted or not. That's all.
My lord.
Were you consulted, Dr. Mojika?
Oh, the affidavit doesn't say on that. Because 14, 15, 18, 19, the dogs.
Otherwise,
whether they are in service, they are retired also. 10, 12 years.
I take instructions. Otherwise, I don't think your pension will succeed. You inform me. There's no patent illegality or patent any irregularity in the way they've conducted the appraisal. You made a representation, they considered it, and the policy says that high average of 5, it won't be eligible. Now it's 7. So yes, you take instructions. Yes.
All 5 years have to be upgraded.
For 5 years is 5. Yes, heard the parties. Mr. B. Kumar, in view of the observations of the court, praised the ability to obtain instructions from the petitioner. Just after, unless you can bring some authority to support your case, just after 2 weeks. Yes. Otherwise, you would have. Yes.
I will take. Much of Lord, deeply Lord.
37.
May it please yours. Very short issue is involved in this case, my lord. The issue in this case is, my lord, whether the lawyer can appear before, or whether the client can be represented by lawyer before appellate authority under information or Central Information Commissioner, my lord, CIC, my lord. The appellate authority has said that the lawyers cannot appear before the State Information Commissioner, my lord. And the said order is against the law, my lord. If I take your lordship to the facts of the case and the issue involved, my lord, very
you for the petitioner? Who's for the petitioner?
I am representing PIO, my lord. Yes, we are representing PIO and PIO.
Okay.
PIO and appellate authority, my lord.
Please, Your Lordship. Lordship, Mr. Paul is on legs before
Where
code 3, Your Lordship. Item 5, code 3, Your Lordship.
My lord, my friend can record the submission and
record submission. Yes.
Yes. My lord, if your lordship will kindly see the genesis of the order, my lord, if your lordship will kindly come to page 15 of the writ petition, my lord, page 15, 1-5.
Yes.
Now, page 5, lordship will have, it is the order passed by the appellate authority, my lord, under the Meghalaya Information Commissioner, my lord. The case was fixed for hearing on 11/9/2024 due to unavoidable circumstances. Hearing was not held on the day and was deferred. The first appellate authority in submission dated 11/9/2024 requested the Commissioner to allow the first appellate authority and PIO to be represented by counsel. Rule 7(4) of the Right to Information, Appeal and Procedure of the State Information Commissioner Rules 2007 stipulates that complainant, appellant may be represented by any person who may not be a legal practitioner. May not kindly mark this. Maybe commission does not allow the complainant, appellant to be represented by a legal practitioner. Thus, one party is not allowed to be represented by a legal practitioner. It will follow that the officer who have to appear personally on the date of hearing. In view of this, so and so, my lord. So the basis of this order is that it does not allow the complainant to I have got the copies, my lord. I'll place everything, my lord. This is the order passed. Now, my lord, kindly see the facts of the case first, and then you'll also in this case, my lord, respondent number 2 filed a number of applications, my lord, under RTI, my lord, and those applications start from page 17, my lord. Sorry, those applications start from, my lord, page 19, my lord. Page 19 to 25, there are 4 applications filed, my lord. Your lordship may not have a look. Those applications are dated 17 January 2024. 4 applications were filed by the respondent number 2, the applicant under RTI, my lord. The replies were submitted by the first PIO, Public Information Officer, my lord, which is at page 27, my lord. Kindly come to page 27, my lord.
Yes.
So the reply was furnished to all applications by Public Information Officer, my lord, on 16th February 2024, my lord, against which, my lord, appeal was preferred, my lord, which was rejected by the appellate authority by wide order dated 12th April 2024, my lord, which is at page 39. So these appeals were decided by the first appellate authority, my lord. Against that, my lord, second appeal was preferred, which is at page 40.
CMD rejected.
Page 40. So we have to furnish the information, my lord, and after furnishing the information,
where's the appeal order?
Appeal order, my lord, your lordship will find at page 39.
Oh.
39. Against this, my lord, against this appeal order, second appeal was preferred by the respondent number 2 at page 42, my lord. Page 42. So if I briefly recapitulate the facts, my lord, on 17th January 2024, 4 applications were filed by the respondent number 2. The Public Information Officer submitted the reply of all 4 applications by 16/2/2024, my lord.
Yes.
On 13th March 2024, first appeal was preferred by the respondent number 2 before the first appellate authority, my lord. First appellate authority passed the order on 12th April 2024, my lord. And on 26th June 2024, second appeal was preferred by the R2, my lord, which is at page 42. 49 is the order, my lord. Kindly have page 49 is the order passed by the second appellate authority, that is Meghalaya State Information Commission, my lord. And the order is dated, my lord, 29th August 2024, my lord, and kindly have page 49, my lord.
Yes.
The page 49, second paragraph, my lord. In view of the above, a hearing is hereby fixed. Hearing is hereby fixed on 11th September 2024 at 11:30 am in the office. The Public Information Officer, Governor Secretariat, and First Appellate Authority, Governor Secretariat, should appear personally. The appellant should appear for hearing in person. This was the order passed, my lord, on 11/9/2024, my lord. Sorry, it was passed on 29/8/2024, my lord. Pursuant thereto, my lord, the appeal was filed, a reply was filed at page 51 by the PIO and First Appellate Authority. Your lordship may have that page 51. And a detailed reply was filed, including, my lord, kindly have page 56, where the assertion was made that lawyer can appear under section 30 of Advocates Act, and it is not barred, my lord. Kindly see paragraph 13, my lord. It is submitted that respondent is being represented by learned counsel as permitted under section 30 of Advocate Act 1961. Moreover, Honorable High Court of Meghalaya in judgment B. Bhattacharjee versus Appellate Authority held that advocate can represent the parties before this honorable court commission. It is also relevant to mention that officials of Rajbhavan have also appeared personally on previous occasions and explained the factual position. More on account of official work, it is not practical or feasible to appear personally in a hearing conducted by State Information Commissioner. A counsel is duly authorized to represent the respondent before this commission. A copy of judgment of in B. Bhattacharya versus Appellate Authority, so and so is annexed herewith and marked is annexed herewith. Now kindly come back to, my lord, the order once again, impugn order, my lord. This is the factual background, and page 15 is the impugn order, my lord.
Page 15.
Page 15, 1-5.
Yes.
Paragraph 2. First Appellate Authority in submission dated 11/2024 requested the Commission to allow the First Appellate Authority and PIO to be represented by a counsel. Rule 7(4) of Right to Information, Appeal and Procedure of the State Information Commission Rules 2007 stipulates that complainant appellant may be represented by any person who may not be a legal practitioner. Commission does not allow, my lord. Now they say that I am above Act, above Section 30, and I do not allow, therefore I will not allow. I will not follow the law. Does not allow the complainant appellant to be represented by a legal practitioner. Thus, one party is not allowed to be represented by a legal practitioner, and it will follow that officers have to appear personally on date of hearing. So the law is, my lord, that the counsel can represent both complainant as well as the respondent, my lord. And kindly see the relevant rule also. It is completely misconstrued by the commission, my lord. If your lordship have rule starts from page 16, my lord. Rule 16 of the 1/6, my lord. Now, Rule 16, my lord, at page 17, your lordship has the relevant rule, Rule 7. And this rule is under the RTI Act, under Section 27, 28, my lord. But kindly have Rule 7, my lord. The personal appearance of the appellant or complainant, my lord. Rule 4 is relevant, my lord. Or I will read the whole rule, my lord. The appellant complainant, as the case may be, shall in every case be informed of date of hearing at least 10 days clear before the date. Appellant complainant, as the case may be, at his discretion at the time of hearing of the appeal or complaint of the State Commission, be present in person or duly authorized representative, or may not be present. May not kindly mark these things. Appellant complainant, as the case be, discretion at the time of hearing of the at his discretion. So discretion is vested with the complainant appellant to either appear personally or through the counsel or may not be present, my lord. Now commission says that no, I will not allow the appellant complainant to be represented by anybody else. Again, against the rule, my lord. 3. Where the State Information Commission is satisfied the circumstances exist due to which appellant complainant, as the case may be, being prevented from attending the hearing before the State Information, State may afford the appellant complainant, as the case may be, another opportunity of being heard before a final decision taken or taken other appropriate action. So in case of adjournment, in personal difficulty, Rule 4, my lord. Kindly see. Appellant complainant, as the case may seek the assistance of any person in the process of appeal while representing his point, and the person representing him may not be a legal practitioner. So the choice is given to the appellant complainant to either appear through in person or through some other representative or through legal representative. It is not that under 7(4), and kindly see the order, my lord, in that light, page 15 against 15 paragraph 2, my lord.
Yes.
And last 3 line, commission does not allow the complainant appellant to be represented by legal practitioner. And it refers to Rule 7(4). Rule 7(4) of the Right to Info stipulates that complainant appellant may be represented by any person who may not be legal practitioner. That does not mean that legal practitioner cannot represent the appellant complainant, and that does not mean that there is a bar under the law that respondent cannot be represented by advocate, my lord. That's a very settled law, my lord. Your lordship's judgment of this court only precisely on this issue, my lord. It came before hearing. This is 2015 SSC Online, Meghalaya 170. My colleague will hand over the copy. Division bench judgment, my lord. And not only all Delhi High Court, Kerala High Court, all your lordship will have paragraph 2 of this judgment, my lord. Respondent filed writ petition bearing WC number 49 of 2015 seeking quashment of impugn order by respondent CIC with prayer to hold that legal practitioner can appear and represent the parties before respondent number 3, and also seek quashment of declaration made in pursuant to Rule 7 of relating to personal presence of the appellant or complainant as validity of constitutional and statutory provision of law. So precisely this prayer was there before division bench, and this judgment was annexed with my objection before the State Information Commission. That your Lordship has seen, not at all adverted to, dealt with. And after dealing with all these provisions, my Lord, Lordship has held in paragraph 12, my Lord, paragraph 12, refers, your Lordship refers to, division bench of this Honorable Court refers to the section 30 of Advocate Act. Under section 30 of Advocates Act 1961, paragraph page 12, my Lord, at page 2, under the section 30 of Advocate Act 1961, an advocate can appear anywhere throughout the territory of India before any tribunal or person legally authorized to take evidence. Since the state CIC has all the trappings of a tribunal, therefore advocate cannot be stopped from appearance on behalf of the parties. On question of representation by counsel, learned single judge has also considered the following judgment of the Honorable Supreme Court passed in so and so. Though the appellant now submit the counsel for the represent should have been allowed by state CIC to appear, but the fact remains that in his affidavit, opposition such stand is conspicuous in absence. Learned single judge referred and discussed provision of 16(2) of Advocates Act that provides for designation of senior. Also noticed that appellant was not unaffected as required under so and so, my Lord. Then, my Lord, finding is there at page 14, my Lord. The appellant at very outset submit that he never had any objection to the appearance of lawyer on behalf of respondent High Court. It also submission that there was no prayer in the writ petition or requirement of appeal pending before Chief Information Commissioner, my Lord. After all this, my Lord, your Lordship has held at paragraph 22 because it was a case in which High Court was also being, the PIO was also directed to be. In paragraph 22 is a conclusive finding of the division bench of this Honorable Court, my Lord.
Yes.
From a careful consideration of rival submissions, it appears that appellant has consistently maintained that State Chief Information Commission can examine the legality of rules framed by the High Court, and the High Court has no right to be represented by counsel before the Commission. The stand does not appear to be correct in view of Section 30 of Advocates Act, whereunder an advocate upon being enrolled has the right to appear before any tribunal or person having power to take evidence throughout the territory of India. Secondly, if there is an issue relating to questioning the legality or validity of Act rule, it can be tested only by High Court under 26 or Supreme Court under 32. Moreover, there is no denial that assertion made in the writ petition that its State Chief Information Commissioner wanted to examine the validity of High Court as regard to submissions without any specific requirement, so and so, my Lord. So ultimately, your Lordship, one issue, we are concerned with the first issue where Lordship has said that advocate has right to appear in terms of Section 30 of Advocates Act, my Lord. Lordship has kindly have the Advocates Act also, Section 30, my Lord. Section 30 of Advocates Act. My friend, my colleague will have the copy also of Advocates Act. Right of advocates to practice. Subject to provisions of this Act, every advocate whose name is entered in the state roll shall be entitled as of right to practice throughout the territories to which this Act extends. In all courts, including Supreme Court, before any tribunal or person legally authorized to take evidence. Before any tribunal, State Information Commission is tribunal. There is no dispute about this. Rule 7(4), my Lord, also does not bar appearance of the representation by advocate, my Lord. So therefore, insistence of the State Information Commission taking away the right of the parties to be represented by advocate is against the law, against Section 30, against the law laid down by this Honorable Court, my Lord, and it is complete misconstruction of Rule 7(4), my Lord. Section 30 of Lordship will have Section 30.
Yes, yes.
Yes, your Lordship has seen Section 30, Lordship. Yes. Subject to provisions of this Act, advocate whose name is entered in this shall be entitled as of right to practice throughout the territories to which state the Act stands. In all courts, including Supreme Court, before any tribunal. And this is section 30 is overriding provision and it overrides all such decisions or bar which being misconstrued by the State Information Commission, and it is in teeth of your Lordship's division bench order, my lord, which we have placed. Now, your Lordship, kindly come back to the rule again. What is the rule says, my lord? 7.4. Rule 7.4 is also not barring the appearance. Rule 7.4 at page 17 of the writ petition, my lord.
There may not be a real practice, also interpretation. Yes, but when is it?
And there are two more judgments, my lord. There are two more judgments.
At the end of
okay, give the judgment. Yes, give the other judgment.
Your Lordship, kindly have this Delhi High Court judgment also, my lord. And Delhi High Court judgment, Pawan Relay 2022 SCC Online, Delhi 3221.
Yes.
And your Lordship, in this, there was a bar, paragraph 3, under the Act also, which was set aside by the High Court, my lord. Paragraph 3 has engaged petitioner number 1 as her counsel in relation to a complaint filed under the Maintenance Act before Maintenance Tribunal. Petitioner was denied entry by Maintenance Tribunal under citing section 17 of the Maintenance Act. In that, my lord, it was denied. Paragraph 8. Division Bench of Punjab and Haryana High Court in Paramjit Kumar Sarua versus Union of India, after considering the Act and various judgments passed from time interpreted to import section 30 of Advocates Act in relation to Maintenance Act of 2007, it was held that section 30 of Advocate Act came into force from 15th June 2011. Much after coming into force of Maintenance Act 2007, section 30 of Advocate Act gives an absolute right to an advocate to practice before all courts and tribunals and would prevail over the Maintenance Act. Division Bench of Punjab and Haryana construed the provisions of section 17 of
okay. Next judgment.
So relying on section and next judgment, my lord, is the Kerala High Court judgment, my lord, 2021 SCC Online, Kerala 1868, my lord. And again, my lord, paragraph 2 to 3 under the Maintenance Act, my lord, Maintenance Act, and provision here, my lord, is what is important is that legal aid was also 2 to 3 identical facts, my lord, that Maintenance Act barred the representation by advocate, my lord. While dealing with this objection, your lordship has seen Delhi High Court judgment. Here, in Kerala High Court has also held that it is the legal aid is fundamental right, and your lordship kindly straight away come to paragraph 51, where the Union of India was supporting section 17, my lord, and dealing with this aspect, my lord, kindly see paragraph 51. Legal aid, lordship, at the foot of the page, my lord, at page 29. Legal aid is a constitutional right guaranteed under 21 of the Constitution of India, and legal assistance cannot be confined only to legal advice, which in our view would not be sufficient in paragraph 51, page 29, my lord.
Yes. Okay.
Last.
Yes,
my lord. Paragraph 51, page 29. Page is at the
last part,
left side. Right? Yes, last. Legal aid, paragraph 51, is a constitutional right guaranteed under 21 of the Constitution of India, and legal assistance cannot be confined only to the legal advice, which in our view would not be sufficient in the interest of parties. Then, my lord, 56, 57. The contention of the Union of India that makers of the Act foresaw the engagement of practitioner represent cases will prolong the matter, will be more harassment for the parties. Last page and so. Paragraph 57, my lord.
Section 30.
As section 30 of, brought into force 2011, Advocates Enrolled Act have been conferred or with absolute right to practice before all courts and tribunals by virtue of section 30 of Advocates Act coming into force. The restriction imposed takes away so and so, and they can appear. My lord, kindly see the kindly have the notification also. My colleague will have notification also of by which section 30 has been notified with effect from 2011. So my submission is, my lord, under Rule 7, this is the notification, my lord, which has brought section 30 into effect from 2011, my lord. My first submission is, my lord, under Rule 7.4, there is no bar.
Yes. And section 30
there is no bar. Rule 7.4 of the rules framed by in 2007 rules have been framed, Your Lordship. So there is no bar under the law or under the rules to be represented, parties to be represented by advocate before the State Information Commission below. There is no legal bar that the State Commission cannot act contrary to section 30 or cannot construe section rule 7.4 contrary to what section 30 says. Section 7.4 is clear, my lord. It gives the freedom to the parties to be represented by person.
The way the words are couched also is that you are allowed to bring a person to represent you who may not be legal practitioner also. With exception,
Yes,
suppose you have a friend who is very adept, so that he can come. He might not be legal practitioner, but he can represent.
Yes, non-practitioner.
It's not a question of a department proceeding where you only get a defense assistant. It's a totally different footing.
Yes,
Now, what has happened? What this court sees is that the understanding of the commission was that it's like a department proceeding where lawyers are not allowed to appear. That's all. You're allowed to bring defense assistant. So it's a contra kind of interpretation that who may not be legal practitioner. They thought that who should not be legal practitioner. But that was then all DPs. DPs like all like that. Yes. Yes, MS.
Lordship, if you can
What
have
submission
the
will you
matter
have?
tomorrow, Your Lordship. If you can have the matter
Tomorrow, court forget everything.
Lordship, it's a small issue, Your Lordship. Lordship,
What they are saying,
since
my lord,
Mr.
last
Paul
time the
is
matter
the...
came,
What is
they are saying that
the
there
stand
has
of
been challenge to
the
rule 7.4.
respondent actually?
And respondent number 2 is the contesting respondent.
Oh no, we
Information
will take it
Commission
up tomorrow. But then what is the stand? I mean, how do you resist this order? Or try to support it with honor? Yes.
What they said before the last
Lordship, if you can have, I was instructed if we can have the matter tomorrow, Your Lordship. As Mr. Paul is still stuck in the other courtroom. Item 5, Code 3.
Okay.
Very short, Sumil. What they said, my lord, what Mr. Paul said, you have to challenge Rule 7.4. Why should I challenge Rule 7.4, my lord? Rule 7.4 is also giving me right. Section 30 is also giving me right. Your Lordship's judgment of division bench also gives me right. 2011 Act has come, Section 30 has come into force, my lord. So there, and Mr. Paul is representing the Information Commissioner, which is a tribunal. Contesting respondent is respondent number 2, my lord. They are basically judge.
They didn't come.
Can't be.
No, Your Lordship, no one is here
For the private respondent? No one appeared ever.
They have appeared, Your Lordship. They have entered.
Counter was filed, my lord.
Yes, the
Counter has
matter
been
heard in part due to the unavailability of the Senior Counsel's behalf, the respondent number 1. This is matter tomorrow in the supplementary hearing this.
Highly obliged.
Grateful, my lord.
38.
Please, Your Lordship. Your Lordship, the learned DSJ is currently on legs, Lordship. So I'm praying if the matter may be taken up at the end of the board.
Only in court number 3.
Lordship. Lordship. If this matter may be taken up at the end of the board, Lordship.
What's the matter of the board, Mr. Paul?
Petitioners are claiming for a lump sum compensation.
In which matter is this? No, sorry, they're serving as what?
They were serving as GD. And
what is
they were
lump sum
discharged from service in the year 2015.
What instruction do we to receive?
Yes, instruction.
Lordship, we've received
What instruction?
One person, they have paid a lump sum compensation of 2 lakh some amount. So relating to that only, we have furnished the details.
Yes.
He was paid 2 lakh 23,000.
Where is he? We take it up because 2 o'clock we have the division bench also. So we take up to when?
Next week.
Next week.
MS Emerichang by Dr. Emery submits instructions have been received. However, and please the matter be listed up to 1 week.
Not.
Yes.
39 and 40 also same.
What was the number of the question? We just take up unlisted matter.
Supplementary 1, item 1.
My lord, this is, my lord, is more or less like a mercy petition, my lord, and I'm not challenging any
understand now
ex parte decree.
Where did it go to legal aid and now it engaging a counsel?
My lord, because now it's so he has no other way out, my lord. Now because it's so what happened is, my lord, he's
let's see the order first.
Yes, my lord.
Because
the order is at page 13, my lord.
23.
No, 5th of March 2026, page 13, my lord. Page 13, my lord. Paragraph number 2 itself has recorded that.
Now, where's earlier when it was filed? Which of the counsel? What's the name?
My lord, the counsel's name is not been reflected here. They said a defendant none. Defendant none. So
now we want to know. See, your main ground is that after availing of legal aid counsel, the matter has gone south. That's all.
Yes.
The simple thing. At least where the grounds are made out with regard to blaming the counsel. You are asking this court to exercise. 226 extraordinary.
Because
extraordinary reasons.
Yes, extraordinary reasons, my lord. Because the promise.
Where the grounds have you made that? You know.
My ground, my lord. My lord, ground page number 6, my lord. Because what I said is, because the petitioner was denied an effective opportunity of contesting the suit.
Where's the sequence of events that he had gone for legal aid, legal was appointed, and then you entrusted the case. I mean, he was apprising you or not.
Yes.
See, that is a sequence of events to show that you were totally in the dark, right?
My lord. My lord, that statement, my lord, I have taken that statement here, my lord. Paragraph 4, my lord, that statement I've taken here. Paragraph 4 of the writ petition, my lord. Paragraph 3 onwards, my lord, that though the petitioner initially entered appearance on 16/2/24, the proceedings subsequently went ex parte by order dated 24/7/2024, that after the petitioner was represented through legal aid counsel.
Now you're saying you appeared yourself earlier on, that means.
When the notice was issued, someone was issued, I appeared.
And then 16/2/2024.
Yes.
Then as per your pleadings, when ex parte, you didn't appear yourself. There was no legal aid counsel at the time.
My lord, probably what happened was during this period, my lord, application.
See, it's not clear here.
Yes.
Then he said that thereafter was represented through legal aid counsel.
Yeah. Yes.
Thereafter means it only went ex parte by order 24/7/2024. So then legal aid counsel came into picture later on.
So what happened in this prevailing period, my lord? His application must have been processed, my lord, because of that, my lord. So finally, when the order went ex parte, he was provided a legal aid counsel, and then, my lord, legal aid counsel was supposed to file an application for restorations, my lord. So which was not done. This is what we have also that is reflected in the order itself, my lord.
Maybe the order will show something. Let's see. Your pleadings are very
my lord,
hopefully inadequate.
My lord, I very much, my lord, handicapped, my lord. But my only point is, my lord, in regard to this client of mine, my lord, Article 39A failed, my lord. The system for him, it failed. That's the only thing that I've come, my lord.
That's what the court you have to show that what happened was after a wheel of legal aid, how you feel and how what happened.
Yes. Well, paragraph 2 in the judgment itself has reflected that, my lord. After the instant suit has been instituted against the defendant, notice was duly served upon him.
1 second.
Where paragraph 13, page 13, my lord.
Yes.
Paragraph 2 onwards, my lord. After the instant suit has been instituted against the defendant, the notice was duly served upon him, whereby the defendant duly entered appearance on 16/2/24. However, the defendant remained absent on the consecutive dates fixed and failed to engage any counsel for his defense, and after ample opportunity has been given to the defendant for his appearance, this court has no alternative proceeding ex parte against that by order dated 24/7/24. Thereafter, the defendant appeared through through legal aid counsel and seek time to file application for vacating the ex parte order, but he failed to do so, hence ex parte order is not vacated. Suit proceeded for plaintiff evidence.
So we still can't discern whether failing to file the Order 9 Rule 13 application is because he didn't approach legal counsel again, or whether it's due to the legal counsel's negligence. That doesn't reflect anywhere.
My lord, most probably
you will give it a story that yes,
yes.
Who's legal counsel? You get the name and have it tomorrow.
My lord, but my lord, only just what
otherwise, see, Mr. Yobin, from what we can see here, is that okay? You received notice, you didn't appear for many consecutive dates.
Yes,
Madam Ex parte.
Yes, that.
Then after you engage legal counsel, you made a prayer before the trial court that we will file an application for setting aside ex parte order, or not order in 13, setting aside ex parte order.
Yes.
Then that never happened.
Never happened.
That means never happens. That can that lapse be on your part, on the part of legal counsel? You're being very conveniently being legal counsel, but by your own contact from the time you appear the first time, you didn't bother to appear.
My lord, what
so he deserves his consideration by his court.
My lord, because what I'm saying is, my lord,
where's that petitioner? He's a violent person here.
No, my lord. He's not, my lord. He's today is the date for attachment of his property, my lord. So he's in the ground, my lord.
He's in the ground, meaning?
He's in the. It is in his shop, my lord.
Where's the plane?
My lord, we don't, my lord, to my limited this thing, there's no plane, only the order and executing order, my lord.
There's no plane also. He doesn't have anything with him.
My lord, these are all with the legal aid counsel, my lord. Whatever I could gather from him is this much only. Very limited. That's why I said.
Plane quoted here in the order, the prayer. Yes.
Yes, my lord. The declaration, my lord. Page 17.
One second. Even for written statement also?
My lord, no.
You have no case.
My lord,
even restored also it's a case of defaulting in rent. That's all.
My lord, this happened during the COVID time, my lord, from there.
2018.
Yes.
That's what I see.
My lord, what I am praying, my lord, is only stay for 5 days, my lord. I will file an appropriate applications, my lord, before the appropriate authority, or before the court, my lord. Because, my lord, here the abandonment of the legal aid counsel has not been informed to me, my lord.
That's not a case. It's not a case for
because my lord, even subsequently, my lord, agreed, my lord.
Given the dates here. Yes. Even legal counsel was given, the file was given to him on so date. It does have to appear, application to be filed. Next date was fixed on that date. They show diligence also. You have no idea.
My lord.
7 witnesses and be other plaintiff.
Because had that, my lord, diligently, my lord, restoration applications.
You're not a person who's indigent also in that manner, because you are renting out his premises of these shops at 22,000.
My lord.
Then
no,
does it reflect the indigent or what do you call it?
My lord, normally here, if you are a scheduled tribe, they don't go to the.
No. It's will all scheduled.
Yes,
fine.
yes.
But even the court can look into reasonableness also.
Yes, my lord, that is true, my lord.
Then, if you are negligent in your pursuit, whether it's scheduled tribe, whether legally, anything it goes.
My lord. My only point, my lord, at this juncture, my lord, is, my lord, had legal aid been little diligent, my lord, should have filed.
What that means you are the one negligent. You didn't follow up with the legal aid counsel,
my lord, because I was not aware, my lord. I was informed restoration application will be filed, and I was a bona fide belief that application has been moved. There was no knowledge, my lord. My case has been abandoned, my lord.
If you have even that shop, you jolly well you would be interested to see whether it's, you know, what is your name? You are Taban.
James Simyong. Taban is the landlord, my lord. Till such time, my lord, I filed an just for 5 days also, my lord. Till such time, my lord, I filed an appropriate applications before the presiding officer, my lord. Or my lord may just give me 2 days of protection, exercising extraordinary power, my lord.
See, the pleadings reflect such a situation. Why not,
my lord?
But they have totally behaved. Orders say anything, it just disappeared.
My lord, as a counsel for my client, I could help. When they go
you have been legally at here also.
No, my lord. No, my lord. He came on Sunday, my lord.
On valuable consideration. See, you've not even given the name legal counsel. You don't know the name also.
There's no reflections, my lord.
If you're making allegation against him, he should be.
Yes.
Should be. See, we also have legal authority, and they come under us. And so, someone's negligent. We have to ask for an explanation.
Yes, my lord. Because here, my lord, what I come to know.
You can't just do everything in your part and blame some poor legal counsel also.
No, my lord. That's not my intention. Is because what I come to know from paragraph 2 of the judgment and order itself.
Now,
my lord,
the execution and 8th June is done. It's done already.
I'm sorry.
Has the execution taken place?
No, my lord. I have been told that it's taking place, my lord. Not yet taken place, my lord. It's taking place, my lord. It's not yet completed the process, my lord.
Taking place means only things are being thrown out right now.
My lord, not ground situation, but it's.
You get information. You go ring up now. You'll see after some time. Yes,
my lord.
You can call 32.
Yes. Let's do it. Where's the petitioner counsel?
My lord.
Yes.
My colleague proceeds, my lord.
Yes.
That part, I've seen.
Yes.
I'm not sure about my undertaking that we will not press that part, my lord. I've seen the pleading.
See, Mr. Shanghai, so
that part. Kindly record my statements. And locus.
How?
Locus. Hurriedly we filed the affidavit, madam, because of course some confusion was there because of that.
Yes, Mr. Philemon, normally they have said that they will not press this for the court. We'll record it. We'll send it there.
Yeah. Lord, there the pleadings are not even complete. Your Lordships kindly have the last order. Yes, my lord.
They are supposed to file.
They've sought time to file rejoinder, my lord.
Rejoinder, ma'am.
You filed
rejoinder was sought by the petitioner to be filed.
Pleadings are not even complete also, my lord. My case is suffering.
But the last order is there.
The order has been filed by the petitioner.
No, my lord. As per information, no.
Last Friday, he sought time to file the rejoinder file and fixed weather for hearing tomorrow.
Where's Mr. Kiriam? Has been filed.
But we are supposed to file it today. What had happened is, my lord, on Friday, the matter before the matter could be taken up, the court said that it will be sitting at Divin's bench. That's why the matter was supposed to be taken up today. So I sought permission from the court to file my rejoinder on their affidavit because I got it only on Thursday evening.
You file a little complicated matters. Yes, we'll record this. Yes, take down. When this matter was taken up, this court of the view to transmit the records of this case before the other coordinate bench, which which is seized with the connected matter, though filed subsequently. Stop. However, Mr. Philemon Nongri, learned counsel of the petitioner, have drawn the attention of this court to the affidavit filed in the other petition, that is WPC number 233 of 2026, wherein at para 12 thereof, an averment has been made before the other court that the red petitioner in the red petition WBC 233 has no locus to assail impugn order, as the same is in issue in the present petition. Faced with this situation, this court had adjourned the matter for the time being to enable the parties to clarify the matter, as it has created a extremely confusing situation where it appears that the respondents are resisting the adjudication of the matter by either court. Stop. Next parameter, senior counsel. Thereafter, on the matter being called second time, has at the bar given undertaking that this averment has inadvertently crept into the affidavit, and that the issues, as in all fairness, should be open for adjudication by whichever court takes up the matter. Those reported that the matter is fixed for further consideration on tomorrow the 9th. Further, the court and though pleas are complete, in the interest of justice, let this matter be placed before the other bench for further orders. Keep going. Otherwise, in the beginning we were ready to transfer to Mr. Chandra, but you're trying to
cat and mouse bench hunting.
Not cat and mouse to preclude to go to court to take the matter call. In that code you say is here, and so you can't take it up.
41? Within 48 hours we filed because of that. Grateful.
My lord, I pay for time 3 weeks.
What is this? Gold.
This is
gold.
Gold.
It appears
they filed a main accused. He has prepared an appeal before this is start.
Then withdraw it.
No.
The main accused gets relief. You will get relief also.
So that will be in fractures now if it is decided in our case.
These are people who seize with the gold.
No. They are the family members.
Who seize with the gold?
No, they are the family members. They have been called for giving witness. They have given witness, and on this basis of that statement, they were penalized. 8 family members.
They were wearing the gold?
No. Okay. They are the family members.
The covering was made from where?
That is from his position. So.
Yes, Dr. Musi, what was your submission?
The main person claiming gold, my lord, he is filing an appeal.
What's the quantity?
It is nearly 1922.
2 kg.
2 kilos?
Yes, 2 kilos.
Worth a lot now, yes. On the prayer, Mr. Endas Gupta, due to the fact the main accused has preferred a statutory appeal before says that this is a matter of the 4 weeks.
Yes.
Much of this.
Second call, supplement 1.
Yes, finish eviction.
Not yet, my lord. Not yet, my lord. Here, my lord, some interesting things have come. When he received summon 2023, my lord, he was given a legal aid counsel by the name of some Bankier, my lord, Bankier, and thereafter, my lord, thereafter, my lord, this Bankier advocate has abandoned the case, which he didn't know, and subsequently, my lord, he was given an advocate by the name of Surana, my lord, legal aid, Sulana, Sheila, 2 ladies, my lord. So, my lord, they are the one was supposed to file an restoration applications, and thereafter, my lord, he was been always say that don't worry, while we are doing it, you carrying on with your business, so forth, my lord. Now that effect can be page 56, where I've written the application. Now this application was by another legal aid counsel, my lord, when everything went haywire, my lord. So in this one also, we have very clearly the legal aid counsel has drafted and he has signed paragraph 5, my lord, 56, paragraph 5. That the applicant to inquire as to how the case has come up this stage found out that the case has proceeded ex parte against the applicant. After hearing the sad news, the applicant then seek from the honorable court a copy of the order where it was found that non-appearance and withdrawal of the previous legal aid counsel. I'm sorry, page 56, my lord, page 56, paragraph 5. It was found a non-appearance and withdrawal of the previous legal aid counsel before this honorable court, So thereafter, my lord, before the execution also, this application,
I want to know whether he had only for one legal counsel before. Anyway, take down.
And my lord, page 60, I have brought to the notice of.
We'll give you 3 days.
My lord, the deputy secretary, my lord.
Yes.
This is also, my lord, I have filed unfortunate turn of event, but my lord, I have reported matter to the legal aid service also, my lord. So I'm not taking, my lord, to take cognizance against the legal aid counsels here, my lord, because whatever they'll do, but I am just asking for 3 days protection. That will suffice, my lord.
Take down this application under article arrested petition has been filed seeking directions to allow the petitioner some time to put in an application for setting aside an ex parte decree and also for stay execution proceedings, which have been fixed today.
Yes, ma'am.
Fixed today by the trial court. Mr. P. Yobin, Learned Counsel, has submitted that the writ petitioner, the petitioner, has been compelled to come before this court seeking exercise of extraordinary discretionary powers under Article 226 of the Constitution, in view of the fact that the petitioner, who is to suffer the consequences of the litigation, is not to blame. Stop. It is first submitted that the petitioner was a defendant.
Yes.
In the eviction suit number 4/2023, and on that occasion, on being served with notice, had that appearance and engaged and had availed of legal aid through legal counsel for representation. Stop, however, he submits, for reasons unknown, the matter went unrepresented, resulting in ex parte order of hearing passed on.
The ex parte order was passed on 24/07/2024, my lord.
24/07/2024. Thereafter, the petitioner engaged different.
Yes, my lord.
Different legal aid counsel.
Yes, I was provided a different legal aid counsel.
Thereafter, he submits, the petitioner was then provided with new legal aid counsels who had assured the petitioner that appropriate applications for setting aside the order ex parte hearing would be preferred, which, however, would be preferred. Stop. This too is submitted. Was not this too did not lead to any further action on the part of the. This too. Oh, sorry. Not this too. In this what do you call the fresh legal counsel he submits. But this is after ex parte decree was passed. This
yes, my lord. Again, when everything went, I applied by
after ex parte order of hearing.
Yes.
Then they said they'll file for the ex parte of hearing. Correct.
Yes, yes.
But they didn't do it.
They didn't do that.
Then ex parte order was passed.
Yes, ex parte.
Then the third legal counsel came.
Third legal aid counsel came, and then on third they filed an application. That application is here at
page 55.
Page 55.
From the from no. Which however was not done, resulting in the decree.
Yes.
Judgment decree dated
of
ex parte decree dated 5/3/2026. Stop. The petitioner then, this was filed on 3rd June, but it's still pending. That means
no, this is my lord. This has been yesterday or the Friday, my lord. This has been dismissed.
Dismissed.
Dismissed. This petition has been dismissed. Because why? Because I invoke order 9 and rule 13 along with section 5.
The petitioner being, he submitted the petitioner being desperate, then contacted legal counsel who furnished an application, who then an application which is next at page 55 to the petition for setting aside, plus the rejection, for setting aside the ex parte decree, what was filed together with an application for condemnation of Section 5 Limitation Act. Where the rejection order?
My lord, this Friday only does pass. We could not obtain the certified copy.
On 3rd June also, which the third, which was dismissed as per the information. So we therefore praise that, having no recourse before this court, with a mercy prayer that he be given 3 days time to put in appropriate applications to enable the trial court to reconsider the matter on the prayer for stay of the execution. You have not filed stay of execution also.
My lord, in this here we have prayed, my lord, here
and
at interim prayer, my lord.
And also for setting aside ex parte decree. Together with, you have to file separate application for
no, separate applications
if any. Stop this court on hearing counsel parties on examination of the materials as available notes that from the decree itself there has been grave negligence both on the part of the legal aid counsels as also the petitioner, who to avail legal aid should have been more. They should have been more
vigilant.
More vigilant, yes, and attentive to the case. Stop. From what has been narrated, it appears that there has been a total failure on the part of legal counsels also to also to assist the petitioner in the matter. This court, in consideration of the facts as they pertain, and though not inclined to entertain this prayer in the form of petition, considering the condition of the petitioner, who appears to be helpless, and in absence of any respondents today, orders that the execution proceedings be kept in abeyance for 3 days, to allow the petition for an application by tomorrow, completion by the court tomorrow itself. Yes. It is made clear that observations that this court not gone to the merits of the matter, and that any observations made herein shall not influence the trial court in any manner in deciding the application of the petitioner. Matter stands disposed of. Yes.
Much obliged, my lord.
42?
Grateful, my lord.
Yes.
42?
Yes.
Well, these are this council matters, well.
Yes. We'll do one thing. See, we have a division bench at 2. After the division bench, we can take this matter up. Yes, you ready?
Now, very limited point, Malad, in this case.
Yes.
Well, what had happened is that the whatever action has been taken by this council has been taken on the basis of the recommendation of one particular committee, Malad. The committee, Malad, has given its recommendation that has been admitted by this council themselves, Malad. Malad, the recommendation was given on 14/5/2025, my lord. Whereas the committee was constituted subsequently, my lord. All the action has been taken. So that's the whether recommendation given.
Before the recommendation came, the determinations already came.
Well, no. Well, what happens is that the recommendation given by the committee was constituted in on 14/5/2025. The recommendation given by the Committee on Administrative Streamlining Improvement (COASAI). So what had happened is 14/5 recommendation was given to the Executive Committee. Executive Committee acted upon that particular recommendation and had issued this order dated 1st July 2021, recommending the casual labor, some of the casual employee to be they have been given a permanent post, prior to that. Those have been retained back to they were pushed back to as casual, and some of them their service has been terminated, The committee was was notified, only on 10 September 2025,
But the action taken prior to that?
Yes, my lord.
They are correct with them.
Your Lordship is like this, because for constituting any committee, normally is the prerogative will be EC.
Of course.
So, yeah, so that being the case, and it has been the practice also for many years.
No, but what Mr. Kiram is submitting is that prior to the council committee, action already been taken.
No, Your Lordship.
Action can be said to be on the basis of the recommendations, or the unilateral action taken by the committee itself?
It is on the recommendation of that committee, Your Lordship.
Then we'll address that. We'll examine that after this.
But the committee was notified only on 10th September 2025.
No, that you please. That's the after we just finish the division bench matter. Any other hearing matter? Huh?
80.
Yes. Will you come back, Mrs. Bonham? You're there in the matter also. What's for today?
Your Lordship, it is
But for hearing, my lords, the reply has been filed.
By whom?
The reply has been by the respondents. My lords, must we kindly have the order of 24th April 2026, my lords. There was a detailed order passed by this honorable court, my lords.
Oh no, because yes, some additional document was filed when the matter was reserved for judgment.
filed a miscase.
had considered that application.
They filed a miscase, my lord, during the pendency.
It was for the obtaining of instructions by the respondents. My lords, may kindly have the order of 24th of April for a minute. Lords, may kindly have para 3 and para 4 minutes of the order.
1 second. Para
3 and para 4 minutes.
Yes.
Because in fact there are 2 para 4s in the effective para 5. Para 3 minutes.
Oh, something
the
wrong.
learned counsel. The
You will read as para 5. Read as 4A, okay? Next para will correct it.
Para 5 specifically says instructions. But the instructions were to be obtained to the effect.
Where are you reading from?
Because I am reading para 3 minutes.
Yeah. Yes.
Page 3. The learned counsel submits that even in the order dated 10th April 26 with regard to another officer wherein the recommendation has been kept in sealed cover, details have been given as to the compliance of the orders of the Sikkim High Court, whereas he submits that in the case of the petitioner, even though the matter was before this court wherein the corrigendum and charge sheet have been quashed, there is no mention of the same. He therefore prays that instant miscellaneous application be given consideration. Once the last paragraph, your lordships, on this paragraph, in this page, though noting the submissions of the learned DSGI, we, in view of the developments which seem to be serious in the nature and having a bearing on the matter, which is pending judgment, the learned DSGI is directed to obtain instructions. Once the instructions were to be obtained with respect to 2 facts. One, my lords, that there is an interim order of Sikkim High Court, which is taken note of in the order of 10th of April 2026 for the promotion. The said order also mentions the name of the petitioner, the applicant herein. And my lords, despite the judgment of 24th November 25, my lords, in our case it is a judgment and in their case it is only an interim order. That is not referred to. One, on this fact, my lords, the instructions were to be obtained. And once the second fact the instructions were to be obtained in is that when the charge sheet has been quashed, and as per the OM of 1992 and the Janki Raman judgment, the 3 conditions which are to be present for adoption of sealed cover process, on what basis these sealed cover process has been adopted, that is what.
We'll hear you after lunch. After lunch. After lunch.
Today I have some difficulty, my lord. After lunch.
Yes.
Today I have some difficulty, my lord.
Tomorrow then? Tomorrow's Tuesday.
Tomorrow is Tuesday. There's a division bench tomorrow.
Day after tomorrow then.
But you are challenging because it is the main prayer with regard to SCR, my lord. Matter was heard.
No, but the thing is that he,
I will show that this is a case for contempt.
He has been made to run from pillar to post.
From the reply.
Yes.
I want to show 2 lines from the reply.
No, put it out tomorrow. We have the hearing at 2. Day after tomorrow, yes, on the due to the personal difficulty of the DSGI, let's the matter day after tomorrow. Yes. We'll have the other matter after decision bench. Yeah, then a matter, no?
No.
Obliged. Made clear.
Yes.
My lord, this is the matter in which the Lordship has already decided the matter. And nothing
Really,
left
this
for
matter can be
discussion.
taken up after 2 weeks, my lord. My lord, we are still in the process of curing the defects, my lord.
So what to do then? We'll dispose this matter.
Because, my lord, it has,
My lord, we fix
your
it after
Lordship,
2
let it
weeks, my
dispose
lord.
of the matter because your Lordship, they want to challenge that order. They are challenging the order. Challenge the order. So it has no bearing. Your Lordship has already decided the main issue.
Yes.
My lord.
Yes, there
That order
nothing
is
left
passed
in
in a
this.
miscase, my lord, which filed by the modification, my lord.
We'll close the whole matter also. We passed the detailed order, I think. When was this?
Yeah, 17th November order, your Lordship.
Yes, we passed a very long order.
Yes, my lord. And your Lordship has taken note of all the aspects. Direction is passed. So nothing left for to be decided in the main matter. They want to challenge the main or matter, let them challenge. But the
Complain if
matter
this,
can't be.
my lord, we fix it after 2 weeks, my
And they
lord.
made
In the meantime, my lord, we will cure
statement
the
like
defects, my lord.
After
Now,
you
my
said
lord,
you filed it, then we file it later on.
It
No, we
won't
filed
come,
it, my lord.
even defects are removed, my lord, it won't come before 13 July, my
My
lord,
lord,
because
the
the
Supreme Court is on
having
vacation, my lord.
vacation, my lord. So there is no purpose. And if they and challenge after
My lord,
that
we
any
fix it after
decision,
4 weeks,
we
my
are
lord.
bound to follow the decision. We are bound to follow the decision,
Yes.
but it can't be prolonged.
MS Adatta, on behalf of the petitioner, prays that the matter be taken of 6 weeks as an SLP against the. No, we'll
Interim
not.
order dated.
Yes. On a prayer, MS Adatta list after 6 weeks. Yes. Avoid any wastage of ink to write the order. When issue of hearing? Yes. Order na you win. No time. I see you have to order on the. Huh? Every vision of anyone. Huh? The IV. All the thing will come in there. What order? Ada type fish bed lah, bisa tahu.
So, my lord must have seen the list, my lord. There, some of them are has been appointed as peon, and
what about this chart?
This is with regard to the post and
27. No, this who made this chart?
30. This particular chart, same chart.
Same chart. You given a copy to Mr. Killam.
This was
prepared by you only.
Prepared by the.
Yeah, I have by my predecessor. Yeah, I have a copy, Your Lordship.
Predecessor in interest, or predecessor in profession.
In
profession.
The posts where some of them have been after the stay order by this honorable court, so they have continued with their work. Some of them are those who have been regularized.
How many petitions are there in all?
It's 6 altogether.
Yeah.
It is 6 now. I'm appearing 35.
Where's Mr. Walang?
Mr. Walang. Morning time was here.
Yeah, morning time was.
Yeah, junior Mr. Walang
was here.
Yes.
Well, the first aspect, in as far as the case of the petitioners are concerned, 35 numbers, notice, show cause notice was never offered to them in the first place. Never issued any show cause notice. No hearing was, no any hearing was conducted.
No, but they casually said.
No, my lord. Some of them have already been regularized, my lord. If your lordship see the
the chart.
The chart.
Regularized. Only number 20.
Yes.
Discontinued.
Some of them have been discontinued, my lord.
Okay.
So, by virtue of the stay order, my lord, they went on.
You know, discontinued ones have been done. I mean, this item number is serial number 20.
Serial number 20, my lord. Yes, my lord. She's there. She's one of the petitioners.
I don't understand. At 17,400 now, 41,000 a month meaning.
Your lordship.
This come to 20. This P I don't understand. At 17,400 and below is 41,000 per month. Means they paid how much?
This is the casual and after being regularized, my lord.
But he has not written regularized against 20, 21.
21, my lord.
20, 21 up to 25, not regularized.
Discontinued from service. But this is the pay which they have received after regularization, 41,000, my lord.
No. This is in this chart. The date of regularization is not here.
In as far as 20, 21, 20.
I'll call you when need. I told him that he didn't tell you. You go. You just finish your work. That will take some time. Okay.
Because some of them are there before your lordship, some of them are not there.
Sure.
Like this is a process server, same. Some of them have been discontinued from service, my lord. So, my lord, after being appointed, my lord, in as far as to the WPC 217 is concerned, my lord.
Yes.
She was appointed as a casual employee with a fixed pay initially at 5,000 rupees a month, my lord. Then after that, my lord, she was regularized subsequently, my lord. She has served around almost 7 years, more than 7 years, my lord, as a peon, my lord.
17.
217, my lord.
Yes, she was appointed in 2017.
Yeah, 17, my lord.
Yes.
So, she was regularized and a pay scale was given to her, my lord. You also will find at paragraph 4, my lord. The petitioner states that subsequently, after serving as casual employee for a period of more than 7 years, the respondent number 2, then White Office Order dated so and so, dated 3rd January 2025, was then pleased to regularize the service of the petitioner to the post of peon in the pay structure of rupees 17,000-41,000 only per month, level 1 plus other allowance. So, the petitioner says that thereafter, upon receipt of the office memo number so and so, the petitioner then immediately joined the post of peon and was remunerated in accordance with the pay structure. We have annexed the order dated order number 21, my lord, as annexure 3. She is at serial number 2, my lord.
Yes.
In the interest of the council, the executive committee KHDC is pleased to regularize the following name casual to the post indicated herein under in the pay structure of so and so level 1 plus usual allowance as admissible under the rules in force with effect from the date and below name incumbent joins the post. My name appears at serial number 2, my lord, as a peon. So thereafter, my lord, she had joined. After joining, my lord, suddenly, my lord, by peon order number 352, my lord, that is at I have annexed the bank statement also, my lord, whereby the money has been transferred into my account. So, my lord, by the impugn order, annexure 5, page 18, my lord. If I may read, my lord. This is office order number 352, dated page 18, my lord, annexure 5, the last page, my lord. Consequent upon the decision of the Executive Committee KHDC, dated 27 May 2025, the regularization of Srimati Korla Idor Hiriamujat as peon, White Office number so and so, dated 3rd January 25, is hereby revoked, and the same has been done. The applicable rule. This order will take effect from 1st June 2025. However, the casual appointment of the incumbent shall continue on. Well, we had approached this honorable court.
Yes.
Hence, the order was passed in the first instance. Then I continued in the same post as a regular employee, my lord. Well, before this order was passed, no show cause notice was given to me.
The order dated when?
My lord, this is
30th May.
The order dated 30th May, my lord. No show cause notice was given to me before this order was passed, nor I was afforded any opportunity to be heard in respect of my case. My lord, the District Council had filed an affidavit, my lord. If your lordship kindly take my affidavit in opposition, my lord. Affidavit in opposition.
Yes.
Your lordship will kindly come to page 8
of the first affidavit.
Yes, ma'am. Page 8, paragraph 10, my lord.
Yes.
That in reply to the above made in paragraph 8 of the petition, the deponent begs to state that upon assumption of office of the new executive committee of the District Council, a committee was constituted to streamline the administrative and improvement of the council, including appointment of the staff of the council. The said committee, during its initial deliberation, discovered that the previous executive committee has issued appointment letters and regularized the temporary service of a large number of casual staff without adhering to the rules and regulation, after which the issue was placed before the executive committee, which in its meeting held on 27 May has taken the decision to revoke and recall all such illegal appointment regularization. My lord, we'll come to page annexure 3, my lord. This is
the affidavit
of this affidavit in opposition, my lord. Annexure 2, my lord, is the list of the candidates who has been discontinued from service.
Yeah.
That is annexure 2, page 13. Annexure 14, my lord. My lord will kindly see the annexure 14. Annexure 3, page 14. Extract of the report of the Committee on Administrative Streamlining and Improvement. recommendation. After series of sitting in the 5th meeting held on 14 May 2025 with thorough deliberation on item number 2 of the terms of reference to review and re-examine the process of recruitment of staff recruitment from the supplementary demand. The committee, after taking into consideration the legal and financial implication of the appointment being done from the supplementary demand, has decided to recommend to the committee as follows. Discontinue, number 1, discontinue of fresh appointment. Number 2, recommendation for promotion, regularize casual staff. So number 1, my lord, the committee recommended the discontinuation of service appointment of 13 fresh appointee recruited under the supplementary demand within the executive and the legislative wing. This includes those appointment to position subsequent vacated due to promotion of existing staff to other posts. List of 13 appointees is attached as annexure. They have not given the copy of that. Annexure A and the corresponding discontinuation order is enclosed at Annexure B. Recommendation for promotees. The committee recommended that the 3 promotees who were elevated to the different posts be reverted back to their previous held posts. Details of the promotee and provided at Annexure so and so. The reverted order is enclosed. Regularized casual staff. With respect to the remaining 30 individuals who were regularized from casual status, the committee recommended discontinuation of the service. However, the committee suggested that they may be offered the option of contractual engagement subject to the consideration of the executive committee on humanitarian ground and in the interest of justice. So these are the recommendation which was given by this particular committee, my lord. The date is very important, my lord. This is dated. This recommendation was given on 14/5/2025. My lord, I have filed a rejoinder against this particular affidavit, my lord. Well, if your lordship kindly come to page 8 of my rejoinder, my lord. Annexure A2.
Yes.
At the outset, the chief executive member welcomed the executive members.
Page 8?
Page 8, my lord, of the rejoinder, my lord.
Mr. John filed on 28/8.
This was filed on 17 February 2026.
Oh. How many affidavits are here?
Filed on 17 February 2026.
1 second.
Page 8, Annexure A2. The CM placed agenda note
1 second, 1 second.
Extract of the
File
proceeding.
on? Yes, page, sorry.
Page 8, Annexure A2, my lord. I have enclosed the recommendation at page 7 also, same the one which I have already read over. Page 7, Annexure A1 is the recommendation. So, extract of the proceeding of the executive committee. At the outset, this CM welcomed all the executive members, including the official present. Then the proceeding of the last executive committee meeting, 18 March 27, was confirmed. Thereafter, the following agenda was taken up for deliberation and discussed hereunder. The CM placed agenda note on the report of Committee on Administrative Streamlining and Improvement and appraised that the said committee has met and discussed the matter on several sittings as per copy of the report circulated to all members. The executive committee in its meeting held on 27/5/2025 has examined the report of the Committee Administrative Streamlining and Improvement, which after deliberation and thorough examination of the appointment of all the 43 staff, it can be discerned that the posts to which they were appointed regularized are not sanctioned posts, and moreover, there is no financial justification of additional revenue received to meet such expenditure. Secondly, these appointment regularization have been done in contravention of the service rule. The executive committee has also given due consideration to the fact that some of the employee staff have been in service for a number of years But the fact remains that since their appointment is against the rules, if their service is to be regularized or retained, then it would set a bad precedent, and moreover, such action is against the larger public interest. Thus, those who have been given regularized as enforcement constable, junior engineer, or any fourth grade staff in their service employee, the regulation order will be revoked, as the same has been done the host of the applicable rules. However, the casual contractual appointment of the incumbent staff shall continue with effect from 1st June 2025. Accordingly, the Executive Committee, after careful examination of the records, has accepted the report and the recommendation of the Committee on administrative streamlining and improvement. Well, it will kindly come to the next page. Page 9, Annexure A3.
Yes.
My Lord, committee was formed. Recommendation given to the Executive Committee, placed before the committee, already accepted, my Lord. Already been accepted. My Lord, interestingly, my Lord, by this notification dated 10 September 2025, I'll just read out, my Lord. The Executive Committee is pleased to constitute the Recruitment Committee to streamline the recruitment process as provided in Chapter 3 of the KHADC Service Rule 1961, comprising of the following, my Lord. So, my Lord, by the committee has already taken a decision. They have said.
How can you appear in this matter now?
No, Your Lordship, I think it's a wrong quotation with the committee. Let me clarify this point first.
You are a chairman of this committee.
No, not chairman of this committee, Your Lordship. That is a different
part of this committee.
That is different committee. No, I'm not a part of this committee. Your Lordship.
No, I see, Mr. If there are any conflict of interest, now how can you appear in a matter that if you are
No, but Your Lordship, this is a recruitment committee. It is not the committee on administrative streamlining. I have the copy of the list of this committee with me, Your Lordship. And
no, I understand that, but is this connected to the earlier committee, pursuant to recommendations of the earlier committee? They've been put in place by the State Council, and this recruitment committee constituted with you, the chairman, in continuation of the implementation of the recommendations?
No, it's totally different.
Totally different.
Yeah, totally different.
Yes. Otherwise,
in fact, this recruitment committee doesn't come into picture, but I think somebody just linked like that, but it's not part of this.
By the court, if we find that there's some correlation or some link, then you have to get another lawyer. Anyway.
Of course.
Yes.
Yeah.
Yes, please continue.
Yes. Well, so, my contention,
not that one.
My contention is that, my Lord, because this we have received after filing of the RTI, my Lord. We have filed an RTI praying for the notification. This was supplied to us, my Lord. This particular notification, my Lord.
What's the notification read?
The Annexure 9, my Lord, Annexure A3.
Yes. What does it say?
The Executive Committee is pleased to constitute the Recruitment Committee to streamline the recruitment process as provided under Chapter so-and-so. So, with the following members. The terms of reference of the recruitment for direct recruitment to various categories for permanent and temporary or tenure as to be as follows. The Recruitment Committee of the Council, comprising of the Chairman, Member Secretary and 2 members, shall be appointed and notified by the Executive Committee from time to time. The Council servant not below the rank of Joint Secretary to the Executive Committee shall function and ex officio member secretary of the Recruitment Committee. The committee shall explore and find out qualified experienced persons and appraise the Executive Committee for co-opting the subject expert for recruitment, permanent, temporary, tenures pertaining to civil engineering, water resources, engineering, architecture, surveying, town planning, forestry and law which are technical in nature. An Executive Committee shall issue a notification to that effect. The tenure holding the chairman and the members of the Recruitment Committee shall be of 2 years and may extend by the Executive Committee when necessity arises. The period of extension shall be decided by the Executive Committee. The chairman and members are entitled to annual honorarium and sitting fee as prescribed and approved by the Executive Committee from time to time. Subject expert is entitled to sitting fee prescribed by the Executive Committee. The Executive Committee shall notify the Recruitment Committee on the vacancies which are within the purview of the Recruitment Committee from time to time. The Recruitment Committee shall advertise, conduct written examination, tests and personal interview for all vacant posts wherein administrative approval and sanction are accorded and convey the Executive Committee in accordance with the eligibility condition, educational qualification, experience and job description as prescribed in the KHADC Rules 1961 and or any order
But
notifying.
they're like MPSC only.
My lord.
High Public Service Commission.
Yeah, like MPSC, your lordship.
The recruitment committee shall do its utmost care to keep the question paper safe. So the recruitment committee shall exercise utmost care to ensure fair and transparent. My lord, the
no, what
15, my lord, 15, your lord, page 10.
Yes.
The recruitment committee shall examine and recommend all matters relating to appointment, procedural and recruitment policies to the committee as per provision of law, my lord. So in my respectful submission, my lord, this committee has been constituted subsequently on 10 September 2025, my lord. So if this is a notification for the committee to be notified for recommendation, so whatever committee which has been constituted earlier and the recommendation which has been given by the committee to the ex-committee KHDC, whereupon the EC KHDC has acted in the termination of service and reversing back the regularized employee to casual, would be illegal and void in law, my lord.
But then this is recruitment only. It's not.
No, my lord, this is recruitment only, your lordship. Correct. That is the position.
My lord, we'll see 15. 15 is very clear.
Have you filed this? Does it clear any affidavit?
No.
Why?
I have just received it today only.
No, I also no, because this has got no link with this recruitment committee. That's why.
But it has link with the recommendation. This is a recommendation, right? This is the first. What's that? CO whatever. The notification.
Of course, that is
yes, with the CM, then whoever.
Oh, this one I got only today. So then I can file a rejoinder, your lordship, to that effect.
We got to record affidavit, no? Well, they didn't know now. They are being as contentions on this because they thought this notification,
we were provided
which is with regard to the that committee which has recommended all these actions. Now you say recruitment, and then this is different.
Well, we had filed for RTI. That's why this notification.
No, in terms of reference, he didn't get.
No.
Should I file in the affidavit?
I beg your.
See, the thing is that now we have to see from the source, right?
Yes.
Now, what has happened that they've been terminated or deregularized or put back? Now those things are there.
Yes.
Now we have to see where the source of all these your actions, right? So your source action, you see that there was a committee was constituted for streamlining the administrative process.
Yes,
correct. What has happened earlier on, and so this committee was formed with these members with these terms of reference. That should have come in the first affidavit. This recruitment committee that you are part of, that's a subsequent action for future recruitments, correct?
Yes, your lordship.
Then?
Sorry for that. Then, if you allow, you permit, your lordship, I can file the rejoinder.
Otherwise, your case will get weakened.
Okay.
See,
then kindly give us time, your lordship. Yes.
See, the committee is entrusted with following responsibilities: to conduct a detailed review of the present administrative procedure and identity, efficiency and redundancy. Because this is the procedural part. The other part, of course, on law, which they will argue regarding natural justice, and that will come later on.
Yes.
But the thing is that at least all the materials should be placed on record. Take what the Peter take down. You're there. Just take down and you get them. Yes, in the course of hearing, Mr. W. Kulab, learned counsel for the respondents, has produced notification dated 20/03/2025 showing the list of members and terms of reference of the Committee on Administrative Streamlining and Improvement. Stop. As this has great relevance for the purpose of this case, he submits that as it has great relevance for the purpose of the case, he prays that he be allowed to place the same by way of an additional affidavit
Rejoinder.
Within, no, not rejoinder, additional affidavit.
Okay.
Yes, within. You type it
10
out
days.
again.
10 days, Your Lordship.
Within 10 days, but please type it out again because this is
Yes, yes,
not
yes,
eligible.
Your Lordship. Definitely.
Yes, hearing is just after 10 days. Yes. But this changes the whole thing.
My lord, we were supplied because we had filed an RTI saying that kindly give us the notification.
Didn't give.
Notifying. They have issued us this particular notification, my lord.
Which one?
The one which I read out, my lord.
That's why
No,
take up as a point of argument.
But RTI, I think you asked for the RC. I think I'm not very sure because at that time I was not there.
Anyway.
Interim orders till today.
We didn't want to continue to further orders.
Yes.
Okay.
This is very important.
They have never filed it. Even I think my friend also have received it today only. He said today morning.
I was
No, because you see, it details all the committee meetings that we held. We will have to file a second, I think, this case, something to challenge the proceedings. God knows. Anyway.
Yeah.
Don't we?